Again, thank you all for coming. I know this is a little different than what we've done in the past with the UnConference. I'm Jennifer Alvarez with Atlas Language Services. I'm your conference chair. You need anything, reach out to me. If you don't see me, jump on the app and you can attendee connect with me. I believe I've friended all of you, so if you accept those friend requests, you can reach out to me and ask me any questions you need. I'll direct you in the right direction. I will be making updates on the app repeatedly, constantly, so when you're on the app, top right-hand corner is a refresh button. Constantly hit that because I'm constantly making changes and updating the agenda and keeping everybody up to date on everything. When, yes. In there, yeah. I am not jumping in the middle of that. Yes, I will re-forward you. Maybe you did block me. I will re-forward you the email so that you can get that, and it'll be faster than going through the App Store. But it is in the App Store under association of. It was through ALC through Constant Contact, so it might have blocked. But definitely keep refreshing it. Make sure you're on there. The agenda will be on there. The rest of the schedule of the next 2 days is on there. So I'll be making those changes. If you've already gotten your badge and you have not done your dine around restaurant, sometime during break, head out to the table out here, pick your restaurant out of the box, and that's the restaurant you'll go to. But we'll have a lot of fun with that. In the meantime, I'm going to introduce Susan Amarino, Liaison Multilingual, and our Vice President of the ALC.
Thank you, Jen. I'm going to do a faux pas and step up. Doing the faux pas, you're not supposed to do that on the stage, I know. So I want to thank every one of you for being here. My name is Susan Amarino, and I'm with Liaison Multilingual Services in Denver, Colorado, and I am the Vice President of the ALC. We have the distinct privilege of having an opportunity to hear from some really amazing experts dealing with worker classification. I cannot wait to learn more about what's going on, and I hope you've got a lot of questions, as do I. I would like to start by introducing two of our moderators. One is Dr. Bill Rivers with JNCL, NCLIS, and also Rick Antezana, who is also the president of the Association of Language Companies, and he is a partner with Dynamic Language.
Perfect. Thank you so much, Susan. Thank you, Susan. Appreciate that. And to echo your words, I really appreciate everybody being here. It's important, I think, right now to be active in this climate. The Advocacy Forum that we're running right now, I think you're going to learn a lot from. We had one in August already with the cooperation, really the direction of JNCL and NCLIS. And so for this one, we're fortunate to have three great panelists. So let me introduce first Laura Curtis. She's a policy advocate with the California Chamber of Commerce. Thank you for being here, Laura. We also have Luke Wake, a senior staff attorney with the NFIB. And we have Ian Adams, Associate Vice President of Government Affairs, R Street Institute. So from a format perspective, we're going to spend a few minutes with each person first, but eventually we're going to get to some question and answer. And I highly recommend that as the speakers go through the topic, please think about questions that you have. This is not just a monologue. You're not just going to be hearing from the panelists. This is a dialogue. We want this to be a two-way communication, and we're all going to learn something from each other, because this is not, although we are in California, we're focused on California today, this is a national issue, and Bill's going to talk a lot more about that. But let's go ahead and start with Bill, please.
Thanks, Rick. And as you all know, I'm Bill Rivers. I'm the Executive Director of the Joint National Committee for Languages and the soon-to-be renamed National Language Council. We're actually working on the logo now, Chris. I'm looking at Chris, one of my board members. Yeah. And we're rebranding because it's two 501c organizations, a C3 that thinks about policy ideas, and a C4 that goes to Congress and lobbies. And under that C4, I am a registered lobbyist, and we lobby on behalf of the language world in Washington, D.C. About 15 years ago, I was at a standards meeting, and this crazy white-haired gentleman comes over and starts pointing his finger and saying, "You're doing it wrong with your IC 1099 stuff, kid." That was Bill Raper. And I looked at him and "What are you talking about? What? And we need to pay attention to this." And Bill, the late Bill Graper, who many of us knew and loved dearly, was on this before anybody else for the language industry, pointing out that we have this huge problem lurking, especially once the Great Recession hit and state unemployment insurance coffers were devastated, and then states looked to fill them in. Bill pushed that rock up the hill for years, and I think he would be really pleased to see, he wouldn't be pleased by the Dynamex decision, guarantee you that, but he'd be really pleased to see the number of folks here in this room today, and I see a lot of old familiar faces, I see some new faces, and that's excellent, and he'd be really pleased to see the collective expertise that we have here on the stage. You've got really world-class knowledge about what's going on with 1099 IC issues in California and nationwide. So as Rick said, we want this to be interactive. We want you guys to ask questions. We've got questions we can ask, but if we get that far, then y'all have failed, because we shouldn't be asking the questions. At the national level, we're also, in addition to working with the U.S. Chamber of Commerce and the National Federation of Independent Businesses at the national level, we're now part of the Coalition to Promote Independent Entrepreneurship, which is looking at employee classification issues across all 5 of the different federal regimes, the National Fair Labor Standards Act, ERISA, the IRS, employee workers' compensation, and of course, unemployment. And as we know from previous ALC sessions, we've had really good learning about the just bewildering array of ways that you can get in trouble with independent contractor 1099 versus W-2 classification. At the national level, I think things are slowly improving, that 3 out of the 5 are more or less aligned. We're trying to get the Fair Labor Standards Act aligned with the other 3. The problem is that the Unemployment Insurance Act is delegated to the states, and that's up to the states to determine how they implement it and how they pursue classification. Now, in the last 2 years, what we've been able to do at the national level, working with both the Congress and the Department of Labor, is to eliminate the misclassification initiative. That's been closed down. To eliminate, and actually 2.5 years ago, the $10 million a year incentive fund that the Department of Labor had to assist states in pursuing unemployment insurance audits. We showed that particular line in the Department of Labor appropriations bill to a senior Republican, and he said, "What the? We let that thing through?" And that was the end of that. Again, it had slipped under the radar. And then finally, the administrative guidance that the previous director of the Wage and Hour Division had issued in 2015 that said basically anybody who's ever paid anything by anyone is their employee. It wasn't binding, but we were starting to see that cited in administrative hearings and some cases in state courts as part of the reasoning behind the audits. We all know that this industry has been targeted. We have heard this from state departments of labor or employment that, hey, this is a rich target because we compensate our people well in general. And a lot of us are bootstrap entrepreneurs who may have not yet hardened ourselves and our companies to deal with this. So they're going after high value added knowledge-based industries rather than the home health aides or the landscapers, because that's where the money is. It's a direct factor. The unemployment insurance is a percentage of compensation. I want to point out too that the website for the ALC is an incredible resource on this issue. So there's a lot, there are model 1099 agreements, there's information uploaded there in collaboration with Scott Mirsky to help give guidance. It's obviously not legal advice, but it helps you frame your thinking about this issue. And I think with this panel, as I'm going to shift and hand off the baton in a second, California is a sixth of the U.S. economy. There are incredible focus areas for the industry from San Diego all the way up to Northern California, and a lot of different verticals that we work for. So we want to learn about Dynamex. We want to see what we can do in California. And then nationally, we want to take that learning out. And the advice I would give is make sure that you're thinking this through well in advance of being audited. And you may think that I'm in a safe state, a Republican governor, and a very business-friendly state. We've seen in places like Michigan and others that doesn't necessarily matter. It doesn't follow ideology. It's just basically about the bottom line for the unemployment offices. So we want to make sure that you're taking advantage of these resources here today and of the resources that the ALC has put together to help us deal with this issue. And so with that, I'm going to turn it over to our distinguished panelists, and I think we're just going to go right down the line. Right?
Yeah, let's go down the line.
Well, this is great. So thank you. Again, my name is Ian Adams, and I'm with the R Street Institute, which is a public policy think tank. So where to my left you have advocates and people that are working on the front lines, we stay back a little bit and we try to study these issues at the first level removed. So we're not academia. We try to be moving at the speed of legislation, though I will not be haunting the halls of the legislature with quite the same frequency as my friends here. The R Street Institute, as a public policy entity, we do have a particular approach. Our motto is free markets, real solutions. And so for us, worker classification is right at the top of the list of really important and high salience issues for policymakers at this very moment. And that's because, as I'm sure you've all noticed, there are all kinds of conversations going on right now about automation and the future of the economy and the future of work. I can't even begin to get my head around how many emails I've now received with the title Future of Work and been to panels discussing the future of work. Well, the future of work starts with figuring out what the heck is going to be going on with this classification binary that we still live with, and in the context of a decision like Dynamex, that we seem to be moving back on. So that's where we start from. That's where our perspective starts from the position of attempting to study this issue, to understand and bring the facts to policymakers so that they can make really informed decisions about how they want to move forward in the wake of a decision like Dynamex. Our basic perspective is that this binary for worker classification is largely outdated. It goes back over 100 years, and at this point, it's one of those things where it's actually hurting those who are in the workforce, because at the end of the day, flexibility is absolutely vital. And what happens when you require people to be classified as employees is you're functionally limiting the types of compensation that they can receive. And what's so interesting about this is that if you poll folks who are independent contractors, 88% of them will say that they would elect to retain their status. And so in reading the Dynamex decision, what was so breathtaking about the Supreme Court's rationale is, well, they articulated a normative preference for full-time work when the workers themselves in the field do not share that preference. And so that's really frustrating, and that's something that I think we have to bring to the fore as we educate lawmakers about this and they come to understand how industries like yours will be impacted. I would say that the other half of this conversation is talking about what the alternatives look like to this binary if we're going to get past it. So whether that be portable benefits, whether that be some sort of third way, I don't know. You know, there are lots of ways to sort of split this situation. I know both of you are working on some of those ways to figure out a way forward. But I would close in saying that finding a way for policy to encourage security for workers while also preserving opportunity is what we're ultimately seeking. And either way you look at it, Dynamex isn't helping achieve those outcomes. So I look forward to the conversation today. Thank you.
Thank you.
Hi, thank you. I'm Laura Curtis. I'm with the California Chamber of Commerce, and I'm a policy advocate for them. Prior to that, I was a practicing attorney in labor and employment, so I have seen the actual issues that this faces for business and the workers themselves. And I am in the trenches when it comes to Dynamex and working with the legislature and trying to come up with some sort of fix. We at the Chamber had tried to motivate the legislature to take some action in August to essentially pause the implication of Dynamex and allow it to, except for the parties involved in the case, to not apply until we had enough time to come up with a task force and some, informational hearings to really think this through and come up with a new test for California. But what we were looking for was simply a pause until the new governor came into office and until everyone resumed after session had ended. And so unfortunately that didn't come to fruition. The legislative members were swamped with their own issues. As you can imagine, California was actually burning at the time, and there was a lot of focus on the wildfires, and unfortunately it just wasn't something that people really had an appetite for because it came so late. So just to kind of give you an idea of that, the case came out in April of last year, and then there was some amicus briefs and other briefs filed to deal with the retroactivity piece, which we'll touch on and go into more detail in a little bit. But so the case wasn't actually finalized until approximately July, and that's when the legislature went out on summer recess. Then they reconvened in August, and August is when we made a push for the pause. And again, like I said, unfortunately that didn't come to fruition. So we are currently working on potential legislation. There are a number of bills which I can get into more detail on, but that are out there already that are working on Dynamex. And then at the chamber, we're working with labor and the business groups. We're also working with the workers themselves. We've created an I Am Independent coalition. It's imindependent.co. I encourage anyone that's interested in this to please look that up, please join. All I can say is that the more involved you get, the more likely we have a chance. Because as you know, there's supermajority in both houses, and the business community isn't necessarily the ones that are always successful in that kind of environment. And so the members themselves really need to hear from especially the smaller businesses, especially the workers themselves, and especially those that are actually being affected and that see how that's going to affect their business and in California, because those members really do care what their constituents think and what their constituents say. And so that's kind of my push for everybody to actually get involved. So I encourage you to do that. And of course, as we continue with the panel, we can get into more detail as far as where we're at politically right now and what the future looks like for Dynamex.
Okay. I'm Luke Wake. I'm also in Sacramento with the NFIB, specifically the NFIB Small Business Legal Center. So I'm not a lobbyist, but I am an advocate for small business. We file a lot of amicus briefs in the courts, and we're trying to do a lot of educational things, put out resources to help small business owners in navigating these really difficult issues. And I would just let all of you know that actually the Legal Center at NFIB has put out a really great sort of general guide to independent contractors, dealing with independent contractors. And if you Google NFIB Guide to Independent Contractors, you'll find that it's a great resource. It doesn't take into account the Dynamex decision. It was published before that. But while we are talking today about Dynamex, it's important, as has already been alluded, to make sure that you're complying with independent contracting rules in whatever state you are dealing with. And unfortunately, this is a notoriously difficult area of the law for especially for businesses that you don't have in-house attorneys. Most of our members, at least, don't have in-house HR. So, sorting out legal issues is difficult in general. But this line between an independent contractor and an employee has been difficult for a long time. Part of the problem is, I'm sure we'll talk a little bit more about, is that you're dealing with all sorts of different tests. At the federal level, the Department of Labor has a different test than the IRS. And every different state has, most of the states sort of conform either closely to one of those, the DOL or the IRS standard, but they all have their own little idiosyncratic wrinkles. And then, these ABC tests that a number of states have adopted are more rigid than the federal tests. The federal tests are, there's two different federal tests, but they're both basically balancing tests. And they ask a few questions, and there's a weighing, and how much control you're exerting over the worker is, very important, and that analysis. But these ABC tests that a number of states, not just California, have, you've got to pass A, B, and C. There's no balancing. But California's articulation of the ABC test, and it was not articulated by the legislature, which is supposed to be the policy-making body of the government, came from the court, which was, I don't believe any other jurisdiction has an ABC test that was imposed by a court. And the really bizarre thing here was that the California Supreme Court gave us this new ABC test, which we'll get into the meat of, I'm sure, but it really was a shock to everyone, because employers in California for decades have been relying on this multi-factor common law-based test, the Borrello test, which No one factor was dispositive, and it was a weighing. And now we're suddenly slapped with this, 3-prong test. You've got to meet each factor. If you don't, you're looking at massive liabilities, major lawsuit, and an open question right now about whether you can be, hit for retroactively, even before the Dynamex decision came down, which is just crazy. Anyways, I'm happy to, looking forward to talking with all of you about this, but I do want you to know just at the outset that we've got some great resources for you, and definitely have some policy ideas that I'm happy to talk about.
Much appreciated, guys. Thank you so much for that initial start. I'll just be brief with my section to just kind of reintroduce things. I'm Rick Antezana, current president of the ALC and a partner at Dynamic Language of Seattle, Washington. My sister, Sandy, is my business partner here in attendance, and she and I, to give you a little bit of background on our legislative efforts, we actually did make, we put together a small coalition in the state of Washington, and we tried to get an exemption put in place for the language industry workers in the state, interpreters, translators, etc. Ultimately, we were unsuccessful, and we can get into the details of that later, but it was a very educational process, and we learned a lot. And we also learned that Washington State is not the only state that's being affected by the worker classification issue. I know there are people in this room that have been audited, that maybe are currently under audit at the state level, at the federal level. Chris, I just noticed you came in, and I think you went through that pretty recently. Hopefully with flying colors, we can get the details later, man. All right, thumbs up. But ultimately, this is an issue that we should all be very, very aware of. And as Bill said, how do you protect yourself? How do you harden your business so that you are as protected as you can be? That's exactly what we're going to get into. And I think, through your questions and through the knowledge of this panel, we're really grateful that you guys are here. That's what it's going to come down to. I will mention that the ALC, we did get behind the I'm Independent movement, so our logo should appear there, and certainly we can get the word out even more to our contractors and the workers that support our industry, and to support what you were saying, Ian. I think the percentage that I heard is it's well into the 80% range plus of independent workers that want to remain independent. They don't desire to be full-time employees. So I think if the legislators pay attention to what's good for the workers, what's good for the economy, we're going to be able to make a difference here, and I think that's an important thing. So again, back to the ALC and what we have done and what we are doing. There are resources in place. If you take a look at the website, Bill did mention already that there are some forms that you can utilize. Chris Carter, I want to give you a huge amount of credit for putting together our knowledge base, which also includes a map, which it's a repository for data related to this issue on a state-by-state basis. Now, the only way it can be populated, though, is by people in each state informing us of what's going on in your state. Are there people under audit? Are there legislative efforts going on? That's exactly what you can let our home office know. And I did want to briefly introduce our new executive director, Mary Connor, who's here at her first ALC event. Mary, welcome. Very grateful to have you here. She's going to be our point person for a lot of the efforts that the ALC is going to be involved with. And so if you can keep in touch with her regarding your state and what's going on, we'll keep everybody informed, and the more organized we can be, the more of an impact that we can have. So what does the future look like for language companies, and how do you protect yourselves? How are we going to handle things legislatively? Let's get into that. So anybody that has a question now would be the perfect time to start. We've got Kevin and Jen with microphones, and they are happy to come around. And here we go. Sandy's got the first question. Or a statement. We accept statements as well.
Hi, everybody. So one of the things I wanted to mention related to our recent legislative effort, I guess it was last year already, we have kind of a unique situation in the state of Washington where we have a group of workers who have formed a union. And so these are independent contractors that are interpreters and translators that formed a union in order to be able to work under the Healthcare Authority contract for the state of Washington. However, they are very vocal, I think that's the nicest way to say it, and they essentially got behind and got all of the unions, the labor unions behind them, and blocked our efforts. We passed in the Senate but they blocked our efforts in the House. We couldn't even get on the floor for a hearing, so it was really frustrating. But I think the impetus of their objections to the independent contractor model is that they claim that they are that they're losing out on benefits, that they won't be protected for worker comp claims, and even though state of Washington has a model where they can purchase their own insurance at a very nominal cost, but they're claiming that that's the whole reason that they don't want this to pass. So I was just wondering if you could comment on that aspect of it, or someone.
Luke, you want to take that?
I'm happy to give a couple responses to that. One, Seattle has tried to unionize Uber drivers who were treated as independent contractors as well, and that's resulted in some litigation. And I know the chamber has been involved in fighting that, and we weighed in with an amicus brief, as well, I believe, at some point, and arguing that look, this is actually a violation of the National Labor Relations Act because independent contractors can't unionize. But then that begs the question: what is an employee and what is an independent contractor? So it's very astute, and it also gets at one of the drivers, I think, here. So on the labor side, the labor advocates always bemoan that there's misclassification, all these bad actors, businesses out there trying to shortchange these employees, as they say, and they do. All of our system, of employment law, Social Security, all of these legal regimes, ERISA. You name it, at the state and the federal level, all the protections kick in for employees, right? And so that is why labor pushes this hard, but there's another angle there as well, as I think they want to be able to unionize, collectivize, and have more power and influence in that way. But I just would push back a little bit on labor there, and a lot, I would say, in that I think that's a poor and inaccurate characterization. I think most small business owners that I talk to are truly trying to just get it right, and it's just a difficult issue. And if they can avoid having someone, if you can avoid having someone classified as an employee, there certainly are a lot of cost savings, not having to pay workers' compensation, unemployment insurance, and just not having to deal with all that red tape that comes with an employee, dealing with leave issues and all that. So but it's not. I don't think misclassification happens as often for this perverse reason that labor suggests.
Any other comments?
Yeah, Washington's a really interesting jurisdiction. I had occasion to work up there in the legislature for a little while, and of course now the legislature has, the Senate is no longer what it was even last year. But Washington is actually one of the jurisdictions where labor advocates under, I think it was SEIU 775, David Rolfe's union out of Seattle, they ran a portable benefits bill up there that would allow unions to work as benefit administrators. I say this because I think that's ultimately what a lot of them are after. They want to find a way for unions to be relevant in a post-employment binary world. And so they're going to continue to fight and win those old fights. But I mean, I've been in rooms with labor leaders, and they understand the direction that this is going and the economy is going and the need to be flexible, particularly on the public side in the wake of something like the Janus decision, right? So I think it actually comes down to some of those subsystem politics and finding a way to be relevant moving forward.
And I was involved peripherally on this. My voice went away.
You're all right. You're good.
They came in, the workers here were talking about unionizing, very adversarial, angry to the point of positioning. It was really interesting. When you sat down, I'm from the state of Oregon, so I wasn't allowed at that little table, but when you guys sat down together, these eyes started opening and realizing a lot of the things you're working towards are mutually beneficial. And so I think part of this equation, we need to find a way to engage the workers into this conversation rather than us saying we're moving forward because we're language companies and we have the right to do this. I think that there should be some sort of initiative, and we could kind of discuss as a group on how to do that. But the state of Washington was a great case in saying, sit down, talk to us. What are you looking for? Here's the thing. Because at the end of the day, where's the statement? 80%, and that's not a made-up fact. Choose to work this way. I have sat at roundtables of the National Council of Interpreting Healthcare conference last year. It was all contractors vying for the right to continue to operate in the way they're operating. And so the big bully companies are fighting for the same thing that the independent contractors want to be, still are. How do we get that conversation a little bit broader?
If I can just tack onto that, Kristen, I think that's a really good point. And I had the same observation during the testimony thing. And the frustrating thing from our perspective as we were testifying in front of the Senate was that there was a fundamental misunderstanding on behalf of some of the interpreters that were there to testify. Literally, they didn't understand the bill. Their testimony was, we don't want to be told when we can take vacation or do this and that. Like, oh my God! You realize, as an independent contractor, you don't have to take any jobs. You can do whatever you want. They thought the opposite. So it was very, very confusing. But I think your point is very good, though, as far as having both the companies and the workers on the same page. And that's part of the coalition that we tried to put together. We actually did have interpreters that did understand the situation testify alongside us, and they explained it really well. We weren't successful that time, but we're hopeful it could change in the future. But I think the I'm Independent movement is exactly what it's about, and something that we as an association can get behind. And so the more organization we can do with that, I think the better.
Yeah. And that's part of what, I mean, with the I'm Independent movement, that we are trying to really educate these independent contractors and the legislature and employees as to why people are choosing independent work. And a lot of that is they understand that they're giving up their benefits, but what they're gaining is the flexibility. I mean, I've talked to hundreds and hundreds and hundreds of independent contractors at this point, and what I hear consistently are moms, retirees, parents, students, people that have parents that they're now having to take care of, that have either been terminated from jobs because they had to take too much time off in order to care for others, or they simply couldn't stick to a strict schedule because of their own physical ailments or because of their own wants and needs, and that they actually need the flexibility. There was one woman who is a driver for some of the on-demand companies, and she was actually homeless. She had 9 children, could not hold down a job because her 9 children kept getting sick because they couldn't find a place to live. And so it wasn't until she started driving for these companies and was able to drive on multiple different, she can drive for multiple different companies at any time she turns on her app and be able to provide for her children now. I mean, and it's stories like that that just really resonate. This is someone that unfortunately, and I won't try to get into too much detail here, but unfortunately California laws are not flexible when it comes to employees. You're looking at split shift premiums. If I am a non-exempt employee and I want to take 3 hours off to go take care of something, if I clock out and then I clock back in, then there's potential split shift premium violations. There's the other issue as far as you cannot waive a meal break. So I can't say I want to leave work 30 minutes early to go pick my kid up or to skip traffic. By law, you cannot waive that meal break. You cannot waive the 8-hour overtime. So if you want to say, hey, I want to work for 12 hours today and 4 hours tomorrow, your employer cannot let you do that. And so it's a lot of those flexibility issues that we are, meeting with the legislature and really trying to educate them on, to let them know that, listen, these people really do need this flexibility in order to survive in California, which is getting increasingly more expensive. And that's what this takes away because our other laws simply don't allow for it. And the other thing that I'll kind of touch back on, which Luke obviously can talk a lot more about, but just for people in general, I don't know if everybody knows what Dynamex did. And so, that basically it took 30 years of legal precedent. I mean, we had what Luke referred to earlier as the Borello factors, which looked at control. Did I tell you when to show up at work? Did I tell you what tools to use? Did I tell you how to do the job? Did I tell you, basically, did I manage you? Was I controlling how you were going to complete the project? Or did you say, hey, I want to work this day, that day, I'm going to choose my own clients. I actually don't like that person. I don't want to have that person as a client. I'm not going to do that work, but I'll get it all, the rest of it to you on Thursday. If that's your situation, that's more of an independent contractor model. If you're being managed by the entity, then that's more of the employee model. And that's what Borello looked at. Well, all of a sudden, overnight, the California Supreme Court ruled that, nope, actually it's got to be the ABC test. A, how much control do you have? Essentially Borello, right? Am I managing you? Am I telling you what to do? B, are you within the usual course and scope of business of the hiring entity, and that's where, Luke will probably go into more of that, but, that's the real kicker for entities. And then the C factor is, do you hold yourself out as, an independently established trade? Are you, do you have currently multiple clients? Are you advertising? Are you saying, hey, I'm out there, this is, I'm a translator, this is what I do as my profession, and then you happen to work for another entity. So, and you have to meet all three. You have to have that. And the courts are looking at that C factor too. Well, how does the hiring entity have to prove that you have multiple clients? Well, how as a business are you supposed to ensure that someone that's working with you has multiple clients the whole duration of that? How are you supposed to ensure that they're advertising? I mean, it's all sorts of, then you are issued with the control issue. So anyway, I think if Luke wants to spend a little more time just explaining those things. Because it's confusing.
No, it is. It's totally confusing. And look, I would, just on the C prong for a second. I believe there has been one court of appeal that has held that in order to satisfy the C prong, and again, you have to satisfy A, B, and C of the Dynamex test. And so I believe there's one court of appeal that has said, but it was, even before Dynamex, it was very important in consideration whether or not they had other clients of their own. But now it's, under this decision, it's dispositive. You've got to have some, well, how can you be an independent business? How can you start an independent business without having a first client? There's always got to be a first client. So, I mean, one of the concerns as a policy matter, when we talk about these independent contracting issues today, you don't want a standard like what we got here in Dynamex that discourages innovation and innovative business models. But B, you don't want a standard that gives larger, more established firms reason to be concerned about their potential liabilities in hiring a small business, that is, up and coming and it's an entrepreneur. The C factor, again, that goes to questions about, whether they've taken the usual steps of someone who's looking to establish a business. So you're looking for, do they have business cards? Are they holding themselves out to the world as being in business? I mean, do they have a website? How much self-promotion have they done? How much investment have they done? And if they're not doing those things, you're going to have a problem under the C prong. But the mere fact, and so one thing I tell people as well is this incorporated? I mean, if it's incorporated, that certainly helps, and it helped even before. But that's not dispositive. You can have, and we had even before Dynamex, this New Jersey Supreme Court, for example, in a case called Hargrove, held that these workers were actually employees, not independent contractors, despite the fact that they had been incorporated as their own LLCs, despite the fact that some of them had employees, And so they failed the ABC test there in New Jersey, because again, New Jersey, and by the way, the Hargrove case was one of the cases that the California Supreme Court relied on quite a bit in the Dynamex decision, and they looked at some other, Massachusetts, which actually before Dynamex was considered to have the worst, independent contracting rules in the country. But there it was done legislatively. There you had as much as NFIB objected, there it was actually.
They chose a bad decision.
They chose a bad decision as opposed to having it being imposed by the courts. The A decision, so the A prong, A, B, C, you got to meet all of them. We've talked about C a little bit, and I'm sure people will have questions about all these. I agree that the A prong really goes to the question of, it goes ultimately to how much control you're exerting over someone, and the Borello factors are still relevant, and the questions about, how much control were you actually exerting, and telling them when, where, how to work, and so forth. But were they using their own tools? That whole list of questions that you would have asked previously is still relevant there.
Can I add just one quick question as far as the A-prong, because I think that's one thing that's super relevant when it comes to this specific area. We're talking about interpreters in particular. I think that's where the bigger issue comes in. And when there are requirements put on language companies by their clients, for instance, in some cases it's about badging. In some cases it can be about proper attire, what's acceptable, what's required by them. So in a case where a language company were to say, okay, interpreter, here's an opportunity for you to take this assignment. Here are the requirements of the assignment, not by us, but by the client. Take it or leave it. From the A-prong perspective, is that a dangerous thing?
Well, first of all, you can have a take it or leave it employment situation, right? So just as you can have a take it or leave it independent contractor situation. So I would say those sort of things, under the previous standard and under the balancing test, the 20-factor test that IRS uses and so forth, those things weigh into the test. But under Dynamex, it's dispositive. If you're, well, again, how much control you're exerting, I guess there's still room to argue about that. One of the problems with the balancing test, the difficulties for employers, is there's all these sort of considerations that weigh into the question of how much control are you exerting. And so, but the fact that you're telling someone to wear something specifically or to do something specifically as opposed to just worrying about the end results, if you're telling them how to go about doing it, if you're telling them where to do it, those are things that would, before Dynamex, would have weighed in favor of viewing the person as an employee. I would say that under the previous standard, under Borello and under the common law test that IRS applies for, any one of those factors oftentimes can be argued different ways, and there's always arguments about, well, how much weight are we going to place on the fact that the person was asked to show up at this time, for example, it's a highly fact-specific analysis, and so there's a lot of room for arguing about the A prong, just like there was a lot of room to argue about Borello factors before. But with the trend we saw even before Dynamex was that the state was getting especially aggressive in how they applied these factors, to the point that I was having conversations with people even in this room who were very concerned. But now it's not just those factors. You've got to prove those factors, and then that balancing factor, how much control you're doing based on the facts. But then you've got to show that they've taken those steps to establish themselves as a business. And then the real killer is the B prong, which is whether or not the work that they're doing is considered to be within your usual course of business. And the way I've explained this before, and I'm sure others have their own sort of take on this, the more essential this worker is and their labor is for your business model, the more problematic it is. In fact, if they're doing what your business does, what your meat and potatoes is, I think you lose under B. So to the specific issue before this room, if you're with the caveat, I'm not giving legal advice. I recommend all of you go out and get your own employment attorneys. But if you are a language company and what you do is translation services, or I'm not sure what you technically would call this, but if that is your meat and potatoes and you're hiring a linguist to do that, you can call them an independent contractors, but they're going to disregard that label and say it's an employee. So,
one unique example that kind of resonates for people with the B prong are doctors and hospitals. Under the corporate practice of medicine, doctors are not allowed to be an employee of a hospital because of conflict of interest and other reasons. But now under Dynamex, a hospital provides medical care to patients, a doctor provides medical care to patients. What are hospitals without doctors? And so how do you get around that B prong? And so that just shows you the core of how impactful this decision was. And then the other thing to kind of also go on your question about the control is that not only is that person potentially an employee of yours, but now are they potentially an employee of the hiring entity who really is your client? Right. And so that's where this becomes even more concerning for people, is that exactly who has the liability? Is it me who's kind of creating the liaison between the two, or is it the end hiring entity? And really, the Dynamex creates a whole new slew of problems with that.
Yeah, what's clear is that lawyers are going to do really well as a result of this.
I consider going back to practicing.
We often identify ourselves as a broker between, the bridges, the linguist who has a specialty focus to the client who needs those services, and we're the one that is aggregating the talent and brokering them. We don't perform the services, so one of those large arguments is one of the main arguments is are they working on behalf of your company? You're a language services company. Do we label ourselves as language service brokers? I don't know, but it is an argument that we have taken that has had some resonance. We aren't doing the work; we are bridging the work to be done. We're a matchmaker. That's right.
And I want to just follow on to what you're saying, Chris, too. This labor model has been in place in our industry for forever, for at least 70 years, if not longer, with 80%, probably an 80-20 mix of independent contractors versus W-2s. And the cases where you have regular employees tend to be very specific. The healthcare system that has enough demand to have full-time Spanish interpreters, which is pretty much the only time you get a full-time interpreter employee, right? Or
But when you cover 230 languages, as our
Yeah.
company does, how often are you using GA and
Carl
and
Kopak,
TWE and
right?
yeah, right.
You know.
And so that conversation has every bit of a presence, as does the common Spanish interpreter. And what you can't do is take a company, at least I do, is we got to continue to identify, at least push one of these angles forward, is say, okay, all Spanish interpreters and Arabic and yeah, Chinese, those are employees, but the others aren't. No, so we're trying to frame as an industry, what does this look like? And so if we, but it is completely unrealistic that any of these languages of lesser diffusion, which we do all day, every day, are, but onesie twosie. Anyway.
And I think that B prong, I know a couple more, I see Naomi's hand up too. That B prong where, taking the looser version of the B, which was outside your regular line or place
Or
of
place,
business.
yes.
And now saying outside of your line of business.
Yes.
And I know Naomi has a question too, but some of the work that you've done, Ian, on the California economy, I think is really illustrative. You look at the film industry, for example, right? I have a cousin who's a hairdresser, and she's an independent contractor for a company that makes films. Now she's helping them make a film. Is that, how's that gonna play out? Things like that. Go back to Naomi, and then I think because we're building up some comments.
Can I
here.
just comment on Chris's comment real fast with the, just as a caveat and kind of a warning, that the way that the courts, all of the businesses that I have talked to have come at us with that, right? We're more of the liaison. And the question is, okay, well, what happens if your translators go away? Do you provide other services? Do you have a business? And the example that I give, just because it's easy for people to relate to, is a hair salon. Again, we don't know what this is going to look like until it's all litigated, and that's why the legislature will hopefully step in. But is that you have a hair salon? Well, they say, well, they're independent contractors. They, now with the iPads, they can pay directly. They have their own book of clients. They have their own hours. All they do is rent a chair. And so the caveat to that is, okay, but are you also cutting hair? Are you also providing services? Are you making money from them in any other way besides the lease agreement? If I'm a real estate company and I'm leasing a chair, that's one thing, because I'm going to have other clients that don't just provide hair salon services. But if I'm still in the salon industry, if we have one salon name, if we have someone that takes incoming calls, how do you handle walk-ins, all of those issues, it's a little bit more of a danger situation. And so the courts, in my personal opinion, and again, this is get an employment attorney, but in my personal opinion, the courts are going to see through that and say, well, where would you be without those translators? And so that's why they should be employees.
And if I can just add on to that, the salon industry has been doing that model for a long time as well. So this is not the only industry where long-established practices are just thrown under the bus or called seriously into question. There is a such thing as having a short-time employee. You can hire someone as an employee for very discrete jobs as well. I mean, that's part of the complications here. If you read the Dynamex decision, I think she's spot on. They really get at this idea that if the labor in question is essential to your business model, then that's going to fail the B prong, which is why this is so very problematic. But one maybe ray of hope, and I think that there's going to be litigation on this to be sure on specifically what they mean by the usual course of business. What is the usual? For example, to give an illustrative example, I talked when I was talking for Assembly Melendez had an event on Dynamex recently. I talked to a gun shop owner, and he said, "I just sell guns, but there's a guy who comes in once in a while and he fixes the guns, and that's not what I do. But he legally is not allowed to do that outside of a licensed gun shop. So what do I do here?" Well, I mean, these are the sort of questions that the courts are going to have to flesh out, I think, at the end of the day. But the ray of hope is that the court did suggest, I think, strongly that whether or not someone is an independent contractor is going to some extent depend on how you frame yourself and what you do to the world, which I think gives some opportunity to sort of position yourself. So if you're framing yourself as being a real estate company, as opposed to Nancy's salon, you're in a better position.
So it's kind of a marketing question from that perspective. What do you how are you presenting what your business does publicly?
Insofar as the question, more precisely the way the Supreme Court suggested is that the question is, how's the consumer going to view are they going to view this worker as being employed by Nancy's Salon or not? And I think most people who go to Nancy's Salon are going to think that the person cutting their hair is an employee of Nancy's Salon, at least the average person off the street.
Wow.
But what happens if you have an employee or an independent contractor that's working for Nancy's Salon? I don't need it. Working for Nancy's Salon and also working for Hairmasters and also working for, you know, the other entity down the road, which in most everybody's case here in this room, you know, we share independent contractors across the board. So how do you define that? How do you make an employee out of somebody that's working for multiple individuals or multiple companies?
I mean, to answer your question, I mean, if they were an employee, you would have to pay them for the time that they spent working for you, and the other employer would have to spend them for the time that they spent working for them. So I mean, it's conceivable, and frankly, that's the test that Dynamex gives us, right? They say the fact that they're working for multiple clients goes to the C factor. You might probably pass the C factor there because they're holding themselves out for, you know, being in business and they're working for multiple people. And traditionally, under the, you know, certainly under the IRS test or whatever, you know, the fact that they're working for multiple people and under the Borrello test, that would weigh heavily in favor of viewing them as an independent contractor. But that is not dispositive anymore.
Yeah, you're gonna, I mean, essentially, if I was a plaintiff's attorney and looking for work, I would say, well, sure, but you could have 3 part-time jobs. So they should be a part-time employee of each of these entities. But again, I'm not saying that that's the case in your situation. I'm just saying that if I was a savvy plaintiff's attorney, that's how I bring the case.
So Naomi, I think you had a comment or a question.
I do have a question. Can everybody hear me?
You're on. You're good.
Okay. I think all of us in this room are facing a tough reality. We don't meet the B part of the ABC test. And everybody says, consult with your lawyers for legal advice. Well, I know what my lawyers told me after the ABC test, and everybody else in the room is going to be told the same thing. The question is, how do we move forward? How do we find a path to compliance? All of us as business owners in this room want to be compliant with the law, but we are left trying to figure out how to do that because there's no practical way to implement the ABC ruling for our industry. So how can we move forward? Do we lie low and hope that everything turns out okay? It's very, very difficult. So I did form a task force. We have many people in this room on my task force. It's come under the ALC umbrella, which is wonderful. Thank you, ALC, for doing that. But our biggest question is, what do we do now? All of us are at great risk. How do we mitigate risk moving forward while we're waiting for legislative initiatives to literally take hold? I want to bring up one case in particular. There was a recent judgment, forgive me for not remembering the details due to jet lag, but it said that the Borrello test applies for most cases except when there is a wage order complaint brought, in which case the ABC ruling and the Supreme Court ruling apply. And I'm wondering if somebody can talk about that in terms of how do we move forward right now, today, moving forward to protect ourselves.
I'm happy to answer that question, I guess.
Please.
So you're right. Certainly the Dynamex decision does present challenges. It means for a lot of businesses and a lot of industries that they have to fundamentally change the way they're doing business, that they have to start treating workers as employees, and that means that you've got to pay them by the hour, or in some cases you may be able to pay them salary, but I think for the sort of work you're talking about, probably not. It is challenging. Now, you know, one option is to just stop working with people in California. I mean, honestly, it is. You know, why deal with someone in San Diego or the Bay Area when you can deal with someone in Houston?
I just need to make this really important legal clarification. This is
So we do have a live audio feed going into our video for ALC.
Sure.
Swap later.
I want to make an important clarification legally, as far as I understand it. Forgive me for intervening. This applies to services that are performed in the state of California. It doesn't necessarily apply to services performed by a California worker outside of the state of California?
No, okay, so let me give you a concrete example. Let's say you have a California legal issue, and you are hiring an attorney who's licensed in California and is legally allowed to practice law in California, but they're based in Indiana or Chicago or something like that. I don't think you have to deal with. I mean, that would be irrelevant because it would be an Illinois employee, it would be an Illinois law would govern her if they were in Illinois, right? So that answers your question. As for the implication, the case you were referring to, it is an important ongoing question as to whether or not Dynamex applies across the board to all classification issues under California law, or whether it applies only with regard to wage and hour issues and meal and rest break issues. That's an important issue. There's been a Court of Appeals decision, as you said, limiting it to those things. But this is what I maybe the others have a different take on it, but for all intents and purposes, I think that's great if you're dealing with an audit from EDD on unemployment, and that gives you a defense, sure. But as a practical matter, you have to comply with the most stringent of all of these tests. So if you have employees in whatever jurisdiction they are, you've got to worry about, I mentioned federal tests as well. You've got to make sure you pass the IRS test and the DOL test. And then here in California, the most stringent test is the Dynamex test. So you're just waiting for a lawsuit if you're hiring, if you're working with someone in California and you're calling them an employee or an independent contractor and they're not properly classified.
Because when you hire someone, right, you're not going to say, okay, well, I'm hiring you as an employee for the way I pay you. But then if you get hurt on the job, I'm not providing you workers' compensation coverage, and I'm not going to help you with the unemployment insurance provisions. I mean, you simply can't do that. When they come through the door, they're either an employee or an independent contractor. So as Luke said, it's great if you're in litigation and then you've already been sued, unfortunately, and now you're trying to divvy up the damages. Then sure, it is helpful in those regards, and you're just dealing with the wage and hour piece. But again, it's not a Supreme Court decision yet, and so that's the other caveat. I know I keep being the bearer of bad news here, but the other thing that you said as far as what can you do, risk analysis, what is the risk of someone suing you? Where does that put you in your business? And that's something that you and your attorney need to go through as your risk analysis. And the other thing that I will tell people is, especially for specific industries, hire a lobbyist. Not me. I'm employed by the California Chamber of Commerce. We're working at this for an entire, for the business industry overall. But hire someone that is specifically dealing with your industry and that is going to have a seat at the table with labor and can negotiate specifically on just your industry's behalf. And that's something that you can do right now because that's where it's being hit right now. So that's what I would say. I'm sure you guys have one, but I would just give that caveat. Make sure that you do.
We do that at the national level, but this is the Unemployment Act is 55 states and territories, and I'm useless to you in Sacramento because I'm a registered lobbyist in Washington D.C. and I don't know the first thing about. I mean, Laura knows where all the bodies are buried in Sacramento and who has what position. But we have at the state level, and something that ALC and JNCL Nicholas have done with varying degrees of success. We've helped out at the state level. We've helped with the California Task Force, which Naomi talked about. We've worked with New York. We've worked with Michigan. We had a Midwest forum that Jen organized, and Kevin organized a few months ago. Our challenge, I think, is that even though this is 6,000 small businesses, if you believe the Common Sense Advisory numbers, and $40 billion a year in U.S. turnover, it's what the frustration I think that Bill Graper had and that still plagues us to some degree is we don't necessarily mobilize until the audits start happening. And then people are like, oh, and depending on the jurisdiction, the retrospective part of that, the penalties and back taxes can be enormous. And people can, if you're a small business owner, you end up writing 2 or 3 years worth of profit and maybe your kid's college or half of your retirement into one big check to pay Virginia or Maryland or Michigan or what have you. But people aren't getting mobilized, at least not until very recently, until the audits happen. And so one of the reasons I think we brought you guys here is because we know we need to be part of bigger coalitions and make sure that we're at the table, because I think what we do is so vital to the economy and to the well-being of the places where we do our work, but we've got to get that story out, and that's why we're here. So.
One thing I'll add on to that too, Bill, and Susan will definitely get next. Excuse me, the advice when it comes to getting an attorney, I'd say that probably step one, get a qualified employment attorney that knows this
California.
issue in your state, in California in particular.
California employment attorney, yes.
Yeah, if you're in California, you want a California employment attorney. But certainly if you're in other states, and I agree, getting organized and getting some kind of legislative efforts going, getting a lobbyist, you can usually communicate with an employment attorney and find out lobbyists' names that are active on this issue and get organized that way. That's how it worked for us in the state of Washington. I actually just heard from our lobbyists yesterday out of the blue, and even though Washington State has, when we started the effort, the Republicans had one side of Congress, now the entire state, like, the governor, all of Congress is all Democratic. And so we thought, well, with labor's strong grip on this issue that we didn't have a chance. Well, she just told me yesterday that the Ds and her, or the Democrats, have really changed their stature on this, and that there really, in her view, is a chance, because they want to solve this. They want to solve the issue. They want to create legislation that is going to clarify the issue, create a path to compliance, as Naomi mentioned, and really that's all any of us want. So there's a chance that the same thing is happening in other states, and why wouldn't you want to get behind that and make change happen? Because what it really comes down to is, in my mind, as a language company owner, it's about ideally getting an exemption. If you can do that, because bundling all these independent contractors or gig economy workers, I would say the linguists don't necessarily fit in this concept of the gig economy. Bill, you mentioned that generally speaking, linguists are highly compensated, certainly more so than Uber drivers or Lyft drivers or whatever. And when you think about the education necessary to be a professional linguist, when you think about the time that goes into it, all of the above, we're talking about two different groups of people. And so what we've tried to do in the ALC is differentiate and say there's the gig economy, but the workers in this industry are part of the knowledge economy. And on that basis, I'm a strong believer that there should be an exemption in place. I know Oregon was able to get that. I don't know how strong that exemption is lasting. Are there some challenges? I guess we'll see. But but those are the 2 points that I just wanted to make to you. As far as an attorney, get out ahead of it. Don't wait until you're under audit. And if you can get organized in your state, let the ALC help you. If you need to find a lobbyist, if you need to find an attorney, talk to us, talk to the Home Office, and we will absolutely help you. I personally have written, I don't know how many letters to people that are under audit as president of the ALC, putting a case together for you, saying, hey, this is our view of this issue, and this is why professional linguists are independent contractors and should be classified that way. If you are under audit or about to be, let me know. I will be happy to help you from that perspective. But Susan, I think you had a comment, or Stephanie?
Yeah,
please go ahead.
So regarding the part-time employee status that you can have, is there a limit to how many part-time companies an employee can work for? Because like the gentleman said, we all pull from we all use the same independent contractors. So that kind of ties into the notion of they're wanting medical benefits and other benefits that employees receive. But now as a part-time employee, at least in California, which is where our agency is based, they're not going to receive those benefits as part-time employees. And I know there's other parameters with hiring part-time employees that a company needs to follow. But I was speaking to a PEO, and that's what she suggested. Is she said, why don't you just make them all part-time employees?
Right. I mean, unfortunately, that's kind of the reality that a lot of businesses that are facing Dynamex, and they're saying, we've misclassified. What do we do now? I mean, the option is either just stop working with the people altogether, or you got to, if you've misclassified, either stop working with them altogether, or convert them to employees, which means all of the, everything from having them fill out I-9s and, but then you get into all sorts of complicated issues. Unfortunately, you've got to, figure out how many employees you have in the aggregate. Why? Because, like FMLA kicks in if you have more than 50 employees. And so it gets a lot more complicated. One thing I would suggest, because you guys, it sounds like most of you guys are small business owners, by the way, NFIB representing small business owners. We, are very active on these issues, not just in California, but, throughout the country, and certainly, at the federal level when they're presented. But a lot of our guys, because they don't have HR, it's just so complicated when you have employees, especially in California, and it's so easy to get things wrong. it's a lot of times a good idea to actually outsource the HR, payroll, all of that to, there are private firms, consulting firms that can handle that for you. And that way you can just focus on your business. And unfortunately, and I was just talking to someone else on a completely different a reporter before we got on here, on a completely different regulatory issue. But my bottom line answer was, this is unfortunate for small business, but it's kind of a cost of doing business now. And that's just the fact. Regulation amounts to a cost of doing business in a lot of cases. And the Dynamex case, I think, illustrates that very well.
Does the SBA have a dog in this fight at all? I mean, do they have any reason to lobby on behalf? Anybody?
We haven't really approached the Small Business Administration on this yet, and I don't think that because they're not implicated in any of the regulatory regimes. I'm not sure that they would necessarily.
I don't know. The Office of Legal Advocacy might be a place to reach out to, because they do have attorneys. But I mean, they would be involved, I think, only insofar as there was a federal regulatory question. But again, this is the federal. You got to meet the federal standards wherever you are. I don't even know. Can I just ask? Because I'm honestly curious in this room. How many people actually do have people working for them in California? Okay, so it's a handful, but it's a lot of you. It's a lot of you, but it's not all of you. So, I mean, these issues are, California is not the only difficult jurisdiction. Massachusetts is very difficult. Vermont is very difficult. New York. Yeah.
Well, what we've done, and as Rick mentioned, in JNCL Nicholas too, I've written a number of letters for folks being audited as well, and I think you can always reach out to ALC, you can always reach out to us, and we're very happy because to help hook people up with the chamber at the state level, with the NFIB at the state level. At the national level, they've been incredibly helpful and very generous in making those contacts. And I think that what we've done, especially with NFIB, we've helped put this issue on the national radar before Dynamex blew up like a 100 megaton bomb. But because that's how we're going to make progress, is building some coalitions at the state level. Yeah. And Oregon and Washington, you guys have. Oregon was way ahead because, again, Bill was a visionary and basically single-handedly got that exemption.
Slid under the radar before anybody knew what he was doing.
Yeah, if you listen to Bill tell the story, he's the one who got the exemption into law. I'm sure he had some help. But,
CLI does businesses in most every state. We get pegged, sadly, too frequently by individuals that are filing for unemployment, and you have to list your last, obviously, and so that's one of our big deals. We have had some success lately. We spend a lot of money fighting it. We hire attorneys in each state for each case and invest way more money than seems reasonable. That being said, we do not want to be caught rolling over. We do a really good job, which we as an industry need to do. Need to make sure that we're sharing information on how to rightfully work with an independent contractor. And I know we've got some information out there. How do we get that word out better? We just prevailed in the state of Pennsylvania. We just prevailed in the state of New York, but and that was at an appellate level. But the Department of Labor came back and said, "Oh no, you made a mistake." But I have every reason to believe that we're going to prevail there, and so we are aggregating all of our wins, and it would be great if other companies could. We have a place to share this. I've got case law in Pennsylvania right here. I didn't have time to get everything else together. But,
Chris Carter's jumping up and down because we've got
jump
the
up and
place
down,
for
Chris,
you.
come on.
And it's our experience. You're always going to be ruled against initially, 100% of the time. You appeal, and if you're ruled against there, you appeal again. It's not cheap, but we find that the higher you get, the more intelligent of a case law judge you get, and we've done pretty well.
Gotcha. So I just want to make one quick plug, and then we had another comment. But if you haven't joined JNCL, NCLS yet, please, talk to Bill, support them. They are doing everything they do as far as industry. You're going to benefit either way, but they have much more of a voice. They're much more powerful the more members that they have.
Thank you.
Correct me if I'm wrong, Bill.
No, absolutely. And I will say with CLI, I know you guys got audited in Maryland too. And what we're seeing, so Maryland's got a moderate Republican governor, a supermajority Democratic legislature, the Secretary of Labor Licensing and Regulation is a colleague, and she said, "Oh, we're going to stop this. We're not going to do any more audits." what she left off was of Maryland-based companies, right? And so there's an exposure there when you're working across multiple jurisdictions. Maybe you're not going to get audited because you're headquartered in a friendly state. But if you've got that person in Pennsylvania who lists CLI or Dynamic as one of their last employers, there's nothing to stop the people in Harrisburg or Baltimore from coming after you.
Yeah, no, I would just on that point though, would mention, as I've emphasized repeatedly here, that you've got to deal with the federal law regardless of what the state law is. So even if you're in the most friendly jurisdiction, you're only dealing with people, let's say, in Houston and Dallas, and jurisdictions you feel like you're going to get a better bite at the apple on these issues. It gets really costly to litigate these things, which is why, some people will err on the side of caution. I get that it doesn't work for everyone's business model. But B, we in the last November elections, we saw a couple states flip from blue-red jurisdictions to red jurisdictions, from red jurisdictions to purple jurisdictions. So, you don't know what's coming down the line, and there's potential, liability. If someone, a different administration has a harder stance, and so, for example, the DOL, U.S. DOL has rescinded the guidance that the Obama administration gave us on independent contracting, which was very aggressive, I would say. They're rescinding, that's great, but you know what? When the Warren administration comes into office, God will, they're going to take a much more aggressive tone and attack. And again, you've got to be worried about retroactive liability. Now, what happens if you realize I've misclassified someone? I mean, I think it's a good idea, like someone else suggested here, to be proactive and go back and actually audit yourself wherever you're doing business, and say, have I misclassified people? If you realize you made a mistake, what do you do then? There's two strategies really. One is say, okay, I made a mistake, and pay back pay or whatever is involved with that. And the other is to try to just hope that no one sues you until the statute of limitations run out, the run out the clock strategy. Under either of those circumstances, it's a good idea to work with counsel and figure out how to deal with it. But anyone operating in California under Dynamex, that's a conversation.
Well, you can't rely on heuristics is really the lesson here. Just because it's a Democrat or a Republican or a friendly jurisdiction as you perceive it.
Right.
The fact is there are how many different breeds of Democrat in Sacramento? Right? There are people who are small business owners in that caucus who will be very sympathetic to the concerns that you bring to them. You can work with those people. There is no question about it. So don't in your mind just assume that partisan disposition is going to be the be-all, end-all as you choose to move forward or how you choose to operate in any given state. It's very complicated just because you might have conservative jurisdictions that are particularly populist, and they may have a real issue with your industry and may go after you as a result of that.
Sure.
I think it's actually a lot simpler than that because Kristen mentioned Pennsylvania. Pennsylvania has been very aggressive through several changes in the state legislature and the governor's office. They've been very aggressive on employment audits. Michigan under Governor Snyder was aggressive. I don't think it has much to do with the political philosophy or whatever you want to call it. It has to do with what the unemployment insurance looks like in that state and what's in the bank. And once the folks in the Department of Employment or Department of Labor, as we've seen, not just anecdotally now, as we've seen, when they find an industry they perceive as a soft target where people are not hardened, where they know they can go out, or they can wear you down and decide you're a small business person, you don't want to spend years litigating and encumber all that risk, and maybe you'll settle. We know that those conversations have been happening, whether it's in Sacramento or Baltimore at the Maryland Department of Labor, Harrisburg, or wherever. I want to come back to something that Naomi asked, because I think looking forward, there's sort of two questions. What do we do right now to protect ourselves? And then what can we do as an industry to, whether it's the Warren administration or the next Trump administration or the Kamala Harris or whatever in 2021, how do we, looking forward, how do we get towards that clear path to compliance? Are we going to have to bite the bullet and make everybody a part-time employee with all of the attendant costs and the disruption on the employees, the workforce side? Are we going to be able to make a stronger argument for some sort of third path or some kind of portability of benefits which would diffuse what the other side with the labor unions are trying to argue? I mean, that's what do we do right now, and then how do we adjust, looking forward? I think there was another question, though, that
We've got a bunch piling up, actually.
Yeah.
Yep. Here we go. Vic Marcus.
Thank you. So in Washington State, we are fortunate to have a Court of Appeals ruling in favor of our industry. It's really industry specific, and having been involved in the effort with Rick, Sandy, Chris, and a few others, what I find is that the legislative effort is very expensive. And when you're in a union-friendly state, you're battling that because the unions contribute significantly to politics. And having met with a local state rep in my district, I was basically told, I get it, I understand the issue, but not in these exact words, but I want to be reelected. So that's what we're faced with. I'd like to hear your thoughts on that. How do we tackle that issue?
We hook up with the chamber and the NFIB because they've got some, they get an audience.
One thing that
whether it's Olympia or Sacramento.
Yeah, I mean, for California at least, the one thing I will say is that the governor himself has recognized that Dynamex is an issue. And all the members of the Assembly and the Senate, moderate Dems have all recognized that this is an issue. So it is something that has a lot of sympathy. The other thing is that it's only being enforced right now through private litigation. So the agencies themselves aren't enforcing this. Obviously, workers' comp and unemployment insurance aren't going to under Garcia, potentially right now. But even the labor commissioner, as far as last time I checked, hasn't issued anything on this yet. So that's kind of why we're in this little bit of a, I don't want to call it a sweet spot because I don't want to give too much of a promise, but that we are in this situation where the members themselves have concerns, and they hear from their hairdressers, they hear from their translators, they hear from their on-demand, and most of them have someone that is an independent contractor, oftentimes in their family, or someone that they know that chooses to be an independent contractor and wants to do that. And that's why right now the negotiations, especially with labor, they're putting the pressure on labor too, to negotiate with the business community. But again, it goes back to that whole thing of, for your industry, you have to raise your hand and say, wait, us too. And obviously, Cal Chamber and NFIB, lobby on behalf of the business organizations in general, overall. But especially with labor, we just want to make sure that no, industry isn't getting a voice and isn't being heard and not making those negotiations. But there really is. There is a good chance with the legislation that something will happen this year. But what exactly that looks like, are we going back to Borrello? No. But is there going to be something that provides some leniency? That's the aim, that's the goal.
And the engagement needs to be sustained. So the member told you, sorry, I want to be elected. Dynamics change over time, but it's also vital not only to be at the table, but to be at the table consistently so that your advocate and your industry, session in, session out, you are always a presence. You are always having your position articulated, because if it's not, you're on the menu.
And with that, go not just to your assembly member, but go to your senator, and also go to the members that you do business in their district. You might not be their constituent, you might not be able to vote for them,
Absolutely.
But at least you're providing resources for their district.
Give them a reason to care.
Yeah.
There you go. Very good. Seamus, I think you had a question?
Yeah. Thank you all for taking the time out to have this discussion. This is awesome. I got a few questions. The California Labor Federation. So we're talking about our side of this coin here. What's happening on this effort, on the flip side of that same coin, and what are we doing to prepare for it? It's question number one. Question number two is lobbying efforts. Understanding the Cal Chamber, NFIB, you're lobbying for other businesses, not just ours, by virtue of what you do. Now this question goes out to everyone in this room that are based in California. What are we doing as California vendors, California businesses, to lobby specifically for us? Can we all get together to do something, put money in a big basket to go towards this effort specifically for us?
I'll say a couple of things here. One, certainly with NFIB, we're actually a little bit concerned about, people carving off just industry-specific things, because we're worried that there's a lot of industries affected by this, and we're concerned that if they just start carving off little industry-specific things, that doesn't solve the problem for everyone else. And we don't want to throw everyone else under the. We try not to throw big business under the bus in the process of not. we've got to be careful about how we do this. Now, granted, at the end of the day, you guys do care about this, and but there's other creative ways to approach it. And again, I'm not a lobbyist, but I know that there are other policy proposals. I'll just mention something here that's come up. You guys pay these people well, right? I mean, when it comes to salary exemption, when you have someone classified actually as an employee, generally speaking, there's an exemption for highly compensated employees, at least in terms of calling them salaried. You can apply the same sort of concept theoretically to create an exemption for that's not the broad solution. I think that either the chamber and NFIB is, but it's something. One of my colleagues in D.C., Beth Melito, wrote a great law review article a couple years ago proposing a standard, a single factor test, as opposed to all these different, weighing and all the balancing, a single factor test that's based on contract law, which would be easy to apply, and they call it the step back test. And I think this would be great. If I was the one writing law, I would love this as the test. And so, you can have a dream thing that you'd like to move forward, and I think we should be pushing for those things where it's politically feasible. But you do have to operate within the political reality. But just the step back test would be great, because it would say, look, I set out the parameters of what I'm looking for and in terms of the final product or the service, and then I step back and let them do it. As long as I step back and let them do it from there, then they're an independent contractor, as long as all I do from there on is accept or reject if they had not done any of my contract specifications. But because even before Dynamex, I just can't stress enough, this stuff was pretty complicated and pretty problematic. I get being upset about the political situation in Sacramento or whatever jurisdiction you're in, because it is frustrating. But again, if you're not at this, at the table, then you're on the menu. And there are creative things. When it comes to NFIB members, I know they like to say, great that you're joining NFIB. We want more people joining NFIB because we have a bigger seat at the table and in the legislature, blah blah blah. But there's also NFIB has a political action committee. I'm sure you guys are doing something along those lines as well. There are you talk to your attorneys about this, but theoretically you could set up a legal defense fund for these sorts of things. So there are things you can do.
The other thing is that op-eds, if you guys, so part of the I'm Independent Coalition that you'll, that the PR firm that we're working with is doing, and as that we represent all of the members that are in the business community that are our membership. And if you want that your specific industry heard, the op-eds are a great opportunity for that. Find, either from the small business perspective, from the independent contractor themselves, and these pieces, they're published within California, gives the legislative members an opportunity to hear from you. Additionally, come up and have meetings. I'm happy if you guys are in Sacramento, and if you're, through the I Am Independent Coalition, you can, have meetings and meet with your members and talk to them specifically. In-district meetings are huge. You guys can do that today. You can call your member and say, hey, I want to meet with you in district, and I want to talk about this because this is a huge issue. Handwritten letters you have no idea how impactful these things are to the members as far as from the legislative side. They really do. If someone sends them a handwritten letter, if a couple people, some of the Democrats that have shown the most interest are simply because they got 50 to a couple hundred letters from their own constituents saying this is a big issue. So those are all things you can do. Obviously, you don't have to hire a lobbyist, so that's not something that you guys are in the position of doing. But through CalChamber, through NFIB, through the I'm Independent Coalition, there are a lot of creative, essentially free ways. You don't have to pay membership to be a part of the I'm Independent Coalition. If you want to add to the PR fund, that's great. You don't have to be a member of CalChamber to be a part of the I'm Independent Coalition. I know your association is overall, but independent businesses can, and then you can have those opportunities.
Can I just give a brief update on where we are legislatively on this?
Great.
And you probably are more in the trenches on this, but so my understanding on this, and you sound a little bit more optimistic than me. I would describe myself as pessimistically optimistic, because I don't think the outlook looks particularly good in terms of getting a legislative change here. You've got Assemblywoman Melendez, who's introduced a bill to just eliminate Dynamex and go back to the Barela standards. And labor has such a grip over the legislature here that that's probably not going anywhere. I'm sure NFIB is all for it. I know we are, but it's probably not going anywhere. And then you've got, I believe it's Gonzalez, Assemblywoman Gonzalez has introduced a bill to codify Dynamex. So I have this big harangue about how ridiculous it is that the court, instead of the legislature, is the one coming up with substantive policy. And she's just saying, okay, let's just codify it. So, and I guess then I couldn't complain about the legislature not making it the law, because then it would be the law. But the one sort of cautious point for optimism, and she's touched on it already, is they're hearing from a lot of people who are concerned, and I think they need to continue to get that pressure if you want them to do anything. But B, there's a lot of open questions, especially about this B prong, and I mean, maybe it's cut and dry for some industries, but there's going to be a lot of gray areas, and even if they're going to keep the ABC test in some way, shape, or form, it doesn't have to be the version that they gave us. They gave us the Massachusetts version, which was the worst version they could have given us, and they specifically chose it because they, in their policy-making judgment, thought it was the best. But that's the sort of thing that, again, legislators are supposed to do and figure out what they think is good policy. And so I think, there's an ego thing here that people who are actually advocating on this can appeal to. These guys, the court has encroached upon their space. And I think the legislature, at the end of the day, is going to want to be the one setting the parameters. And what we get at the end of the day may look a lot like what we already have, but there is some room for even modest improvement. The B prong in other jurisdictions says something to the effect of the usual course of business, or
outside
working
the usual place.
Yeah, exactly. So someone who's like working from the outside of your business, like physically in their home, for example. In a lot of these other jurisdictions with ABC tests, they would be considered an independent contractor.
That's a huge help. I know we've got a few more questions coming up. Syed?
Yes, I have a two-part question. One, I understand from the public meeting we had in Sacramento, the legislators were very receptive for a language that would be, that they would consider it.
Yes.
And you mentioned recently that they had, there are some bill legislation in the works.
Mm-hmm.
Is there a place we could go and view what's in the works?
Oh.
That we could see that how that would apply to us?
So that.
And the second part of the question, the big boys, the Uber and Lyft, they continue to operate the way they operate.
Mm-hmm.
They are really, they continue. What is they have a different strategy than ours? Thank you.
Mm-hmm. As far as the bills that are out there, yeah, the Gonzalez-Fletcher's is AB 5. I can't remember, Melinda's off the top of my head what number. It's like AB 11 or something like that. But that's something that if you email me, I'm happy to send you that, and you can see those bills. But those are published. So Assembly Bill 5 by Lorena Gonzalez is the one that would codify. It's just an intent bill right now, which means that the language in there is just saying that the legislature intends to enact a bill that would codify Dynamex. It's not the actual language of what they're looking to impose. And I believe Melinda's is the actual language. I think it goes back to Brello, but I haven't looked at that one in a little bit.
While we're talking about legislative aspects of this, and I would just mention that this question about whether or not the Dynamex decision, which was pronounced on April 30th of last year, no one would have known that they would pull Massachusetts law out of the hat. It's unfair, fundamentally unfair to say, well, even if you changed your business immediately, the day that opinion came out, you're still possibly liable under Dynamex retroactively, which is crazy. So that's another issue that I would hope that the legislature would address, and certainly we're trying to work that one out in the courts. And myself as an attorney working on these issues, with friend of the court briefs, that's kind of where my head is usually at. Usually I let our lobbyists talk about the policy side of these things. But yeah, a lot of this stuff is going to be sorted out in court. So for example, we filed a friend of the court brief just yesterday, urging the Ninth Circuit to rule that the Dynamex ABC test only applies prospectively, that it doesn't apply against businesses who are operating in good faith under the old standard.
Yeah, the whole thing about no ex post facto laws being made, that was strikingly absent from the Dynamex decision.
And as far as Uber and Lyft and the gig economy, they're under the same situation and now analyzing the risk. And I know that they're currently being sued by individuals for the independent contractor model. They are in a unique situation. I don't know their legal strategy, but they're again kind of in that unique situation where they're essentially a platform, right? All they do is create technology, and their drivers are the one, they're not actually driving cars, so they're kind of in that broker situation. And so it'll be unique to see how that plays out, but they're actively involved in the legislative process to try and help with with what's going on legislatively.
I also think it's really important to have the sort of unified front approach. I know it's appealing to seek a separate piece, to have an industry carve out, but there are a lot of big boys in this room who may want to have carve outs of their own. So being around the same table and understanding that there is a downside to that strategy, potentially. Maybe the legislature actually demonstrates some interest in seeking very specific carve-outs as we start to see the application of this law in individual cases. I would think that would provide the impetus to do that. But otherwise, in these very early stages where, you know, people are just showing some caution as they approach this new law, trying in good faith to be in compliance with it, this is the time to try to be magnanimous and be around the whole table. I don't think we're quite at, we're not quite at everyone fend for themselves right now.
Yeah, and that's, I mean, as far as any sort of legislative fix that NFIB and Cal Chamber works on, it's holistic approach, right? I mean, that's what we're going for, is something to help alleviate some of this pressure from businesses in general.
Great. So rather than take another question, I think, Jen, it's break time, correct?
Yeah, we're going to break 5 minutes early. We're going to come back. We do already know the order of the people that we have some questions right when we get back. We do have that order, and then we'll add to it as anybody else. But we're actually going to break 5 minutes early, just because I know it's been a heavy afternoon. But we are on break until 3:15, 35 minutes now break. So enjoy coffee, soda, let me know if you need anything, but we'll be back at 3:15.
Thank you. So I believe the plan is to continue with questions. Is that right, Kevin?
Yeah.
I think we had a few lined up, and we haven't had a chance to meet yet. Are you Dwayne?
Yeah.
From SmartCat. Welcome.
Thank you.
Please fire away.
So I find this discussion very interesting because as SmartCat was formed, this is one of the things that our CEO and a lot of the team members actually faced is, you know, what makes an independent contractor? What makes an employee? Essentially, we've alleviated a lot of that risk by opening up 250,000 freelancers that are at your disposal to hire, train, test, and actually pay through SmartCat. So if you're worried about, what we found is a lot of smaller LSPs weren't able to compete with larger LSPs because they were tied up. Their hands were tied in a lot of what's being talked about now. It doesn't allow them to free up time to go and hunt new end customers. So essentially, we've built with our payment solutions an invoice that if you do become audited, because we'll pay all of your freelancers with one invoice and send you an invoice back that's tax compliant. So when you're looking to hire freelancers or you're looking for independent contractors, you know, you don't have to entirely assume all that risk. Right? There's other avenues out there, and essentially our freelancers are not SmartCat employees, but legally they fall under that umbrella. And I'm actually sitting at the table with a couple of people that use our freelancers and our payments. They made sure I asked this question or at least spoke.
Yeah.
So instead of hiring a lobbyist, right, which is a good way to go, right? I'd like to have a lobbyist for me. There's a lot of things I'd love to talk about. But ultimately, what are you guys finding is the actual overall issue? Is it just a lack of legislation? Or is it the fear that's holding you back from hiring more freelancers?
You want to take this, Bill?
I think that's actually a question for the other folks in the audience.
Yeah, like, it's more about the company owners,
you know,
right?
The company owners and the California task force in particular to talk about what they're facing. You know, and then not to, I don't want to denigrate anybody's business model. Part of the fear we had with Dynamex is that it was, especially when it first came out, it looked, you know, that very restrictive B test, the retroactive nature, that, you know, the concern we had in California was that no matter what people were trying to do, they were going to get hit with these audits. But I think it's more important to have the company owners talk about where they are and what they're seeing. I don't know.
Well, I'll just mention, though, that, I mean, I'm So I love the idea of creativity and market disruption and doing something that is different, which is clearly doing what you guys are up to. And I'm sure there's some interested people that are going to want to talk to you this weekend at the annual conference, et cetera. As far as how it impacts each of our businesses, though, I think it still depends where are these contractors located. So if they're in California, even though the payment is going to SmartCat, if they're being contracted by a language agency to work at a location, maybe a hospital or a court or something like that, the waters are still fairly muddy, are they not?
Yes.
Okay.
Yeah.
Yeah, I would just add, so let's say you're just operating in the United States and you're only working with people in California and New Jersey or wherever. You have to worry about whatever jurisdiction you're in, right? And I think a great deal of the hesitancy here is you've got to pay out workers' compensation and unemployment insurance, and in California you've got to make sure that they're taking their meal and rest breaks. And by the way, it's very easy for people to allege that they haven't gotten their meal and rest breaks and sue you over that. So there's just a lot of red tape in addition to, and also added costs that I think give people who haven't structured their business in terms of counting everyone who's working for them as employees. Real concern, but on the other side of the equation, there's real concern about liability and litigation. And then, I was talking to you during the break. You're telling me you've got folks doing stuff for you in Egypt or wherever, Moscow, wherever. If you're working with someone in any foreign jurisdiction, I'm not an expert in international law, but you need to rely on local counsel in Russia or Croatia or wherever these people are located to be sure you're compliant with their laws.
Mm-hmm. Valid point. Yeah, exactly. Thank you for that. Kevin, we had another question. Camila?
Yes, hi. So this question may be a little bit more basic. I'm based out of Houston, and this whole topic for 15 years has been a little bit, or we've seen it a little bit of us outside of our reality. So my question is more for companies that are located in friendlier states like Texas. What is the lowest common denominator of what's going on? And what are really our risks at this point? Are we at risk of having the ABC test? Are we, and so on? Because, obviously, the whole conversation has been about Dynamex and California and so on, but that is not the reality of a lot of people here. So I would like to know, what is the lowest common denominator risk for people?
Well, that's why I've been emphasizing throughout this conversation the need to make sure, for all of you who have to worry about federal law. And so I think worrying about in a jurisdiction, a lot of the jurisdictions, most jurisdictions that, ABC test, there is some form of the ABC test in a lot of different states. I'm not a Texas attorney, I can't speak specifically to Texas, but I'm not aware of an ABC test there. In any event, a lot of these jurisdictions will model their tests for, different labor law, employment law, on US DOL law. So you really need to worry about DOL and IRS, in addition to your state agencies. But you could get audited by any of them, even if you're in a conservative jurisdiction.
Well, but not only that, it's great that you have a trade that does fantastic work, because the fact is, at the congressional level, you have congressional Democrats that are interested in seeing the ABC test become national law. Now, will that move in this Congress? No, it won't move in this Congress. But things can change very quickly. So as you sit in Texas, paying attention to the way this gets applied and understood in California is going to be vital risk management for you moving forward, because at the end of the day, if we do have the Warren administration and there's a wave and the Democrats take the Senate, it could move. Absolutely. It could become federal law.
I've got one question that kind of came up earlier. The portable benefits concept was introduced, but I think there's a lot of people that don't necessarily understand what that's about and what the implications would be for company owners. Can one or all of you speak to that?
Sure, absolutely. So with portable benefits, the idea is that independent contractors will be able to, without triggering a full-on W-2 employment classification, be able to enjoy non-cash benefits that currently would see them get lumped into an entirely different category. So they could still be independent contractors, but get other sorts of compensation. And so this was the bill we saw run in Washington. Actually saw Evan Lowe introduce a bill last year in California to this effect. New York has been looking at it, and it's been labor at the table that's been talking about it. So when I think about independent contractor conversations, when I think about an affirmative way to enter those conversations, I think it also has to be with these innovative alternatives for the future that introduce greater flexibility. Because at the end of the day, what is it that the policymaker wants to see? They want to see employees protected. They want to see that base level of benefit that it's almost a private safety net when they think about the benefits that people get from full-on W-2 employment status. So a portable benefit system, there are lots of challenges to it, you know, what the contribution level would look like. There are all kinds of obstacles to be worked out, no doubt about it, to say nothing of federal law, that you would probably need some very explicit exemptions. But at the end of the day, that's, I think, where this conversation has to go, because it's going to get us away from this binary, which, as you see, you're talking about having to redefine how your businesses work. Uber's saying it's an information company. Well, yeah, it's an information company, but it's putting people in cars, right? And so now they're redefining what it is to be a business, and you're asking, well, is it a branding thing? Is that what I need to do to be compliant moving forward? That suggests that there's something wrong with the status quo. And so as you go out there and as you think about the policy of the future, I would be encouraging you to think in creative ways that would include portable benefits.
Yeah, because we hear that a lot, that, you know, there's so much concern now. You've talked about, you know, I'm sure touch on more automation and all of those issues. And so now people are having to splice together multiple side jobs, essentially. And so how, you know, what is that going to look like when that person is entering their 60s and their 70s and they want to retire and they have no retirement fund and nobody's ever contributed to that fund? And so just on a basic level, it's basically like if you had a retirement fund that was mine and anybody I worked for would then contribute a certain percent to that retirement fund, to that healthcare fund, and then you would determine, okay, I want to work with that person because they're contributing, you know, X amount of dollars, and that way there's some sort of safety net for these individuals. But that is a very huge discussion in Sacramento specifically.
I know it is in Washington as well,
Yeah.
so it's helpful to understand that. Jen?
Thank you. My original profession is as a registered nurse, and our golden rule to protect us from liability is document, document, document. So my first thought as far as what can I do immediately is how do I document, you know, what I need to be documenting to show whoever it is that's going to be looking at it. We're actually looking this year, 2019, we're probably going to be transitioning a number of eligible individuals from contractor status to employee, and that's going to be in the state of Michigan. So related to documentation, I have two questions. So the first is, for those individuals who don't want to transition, that choose to stay as an independent contractor, we're thinking at putting some sort of a waiver in place to protect us, to say, hey, we've shown that we've tried to bring this person on as employee. They have said they have fulfilled these criteria and shown that they don't want to work for us. They've had the opportunity to be offered full-time employment with benefits, et cetera. They choose to be an independent contractor. Is that something that is going to be feasible and helpful and useful for us? The second question is related to the requirements that you guys talked about. I was chuckling when you said, you know, we have, you know, thinking about the idea of requiring people to have business cards and market themselves, because I can't even get a vaccination record sometimes, you know, let alone now, now you have to also make sure you have your own business cards and brochures and, you know, try to get some more business. But my thought is, I can understand, like everything else, there may come a point where we actually have to tell people that they have to do this in order to protect ourselves. And so what documentation do we have? Do we make it part of their independent contractor agreement that they understand they have to now have these things? Do we send emails and save all sorts of email chains? You know, what's going to be helpful?
So I referenced earlier, and I recommend people check it out, because this is a resource not just for California businesses, but we have a guide to dealing with independent contracting. So Google NFIB model guide to dealing with independent contractors, and you'll find it. And it gives some concrete, thoughts on how you should approach these things to protect yourself, and how there's no magic words that you can put in the contract that's going to protect yourself. There's nothing talismanic about saying they're an independent contractor. It's really about how you structure the relationship, right? And it's really about how you set up the way you're going to deal with them. Now, I tell people when I'm having these conversations, small business owners across the country, always with the caveat, you should get your own employment attorney. I'm not giving you legal advice, but generally speaking, it is a good idea to, have, just for your peace of mind, to show that they have set themselves up as an independent business, that they've taken those sort of usual steps. So, I mentioned, the fact that someone's incorporated really helps. The fact that someone can tell you, at least, in some sort of written documentation, yeah, I have other clients. I mean, that helps. But, at the end of the day, you still need to be able to show, and I'm talking about other jurisdictions right now, not the Dynamex test. At the end of the day, you need to be able to show that, they're free to decline work, that they're free to, decide how they want to go about doing it and so on. Again, it's a balancing test in other jurisdictions. But with regard to your first question, I would just say this. If you tell someone that you're going to, you can make it a take it or leave it thing. You can say, take it or leave it. I'm going to convert. I'm not going to renew you as a contractor. You don't have to tell them that you're worried about your liabilities. And if they say no, we're not interested, then you can say, I can work with someone else. But if someone is insisting, no, I want to continue to be a contractor, and you still want to work with them, you can do it. But you're taking a risk. There is a potential liability there. The mere fact that they say, no, I don't want to be an employee is not an absolute defense. It may help. In California law, under the Borello test, the fact that the worker considered themselves as an independent contractor was a factor in the analysis, but it's not dispositive. And so, if you have real concerns about whether or not you're properly classifying someone in Michigan or anyone else, consult local counsel.
And the reason that it's not, and then I had a couple of these questions over the break, is can't we just have a contract where they say I'm waiving my rights as an employee. I understand that I'm no longer going to be, or I'm not, going to get these benefits and blah, blah, blah. Unfortunately, in California, again, I'm not sure Michigan, but the reason that's not allowed is because essentially it's seen that the business has more of the power, and so it's seen as the person only signed that because they felt that that was the only way to do work with that entity. And so it doesn't hold, it definitely, if they're signing an independent contractor agreement, absolutely, yes, you want that because you want them to understand they're entering it as an independent contractor. But if you have two people side by side that are essentially doing the same amount of work and the same type of work, one's an independent contractor, one's an employee, in California, that's just going to make it worse.
Those are bad facts.
Yeah.
It's a big red flag, isn't it?
Yeah, it's a red flag in every jurisdiction. In Maryland, and I've seen this in Maryland, and I know there's some Maryland companies here that, again, that side by side, same work. One is an employee, one's an IC. That's going to be seen as a.
I just want to one more point. Just building on that, Michigan law, North Carolina law aside, you got to worry about federal law. And federal law, the DOL, the Fair Labor Standards Act says that you have to pay employees a minimum wage, a federal minimum wage, and you got to pay them overtime. And the standard there is it's a suffer or permit standard. And what that means is if you allow someone to work for you who turns out to be an employee, then you've got to pay them.
Yep. Kevin, you have there we go. Jessica.
Somebody up there mentioned earlier 88% of independent contractors want to remain with that status. I got to imagine that, even beyond the audits, because we're in Connecticut, we've dealt with these audits, every couple of years since 2006 or so. We've been really lucky that we haven't dealt with it in about 5 or 6 years at this point, because I think our case was fairly strong. But I'm kind of bringing up this other side of it, because we also get questioned on our business model from clients, whether it be clients in the healthcare space or in the government space. And we have to kind of go up against the clients and kind of defend our business model as working with independent contractors. So whoever mentioned the 88%, I'm wondering if there's somewhere that we can cite that. Is that an actual number?
It's an actual number. I have a study. I can give you a card. It can be available to everyone here. But as a result of the fact that this issue has risen in its prominence, there's been a great deal of research done on personnel trends. What do people actually want as they work? And as it turns out, those who are independent contractors, they're doing it because they want to do it. And it's so interesting because so much of the fear around this is that as a result of the rise of the gig economy, you're going to see people unable to get full-time employment that they would otherwise want, and just the facts don't bear that out. There are plenty of opportunities for full-time employment, but the fact is an independent contractor can choose where they work. In your industry, they have great wages, and it sounds like there's plenty of competition. And as a result of that, they really like their arrangements. They like the absence of control. And so when you see something like Dynamex happen, it's really the workers who begin to suffer, which is so kind of strange. But yeah, that is absolutely something that you can cite when you're talking to your clients and why it is that you choose to do this model. It's not only because you're able to, through your business model, provide the best value to your clients. It's also because you want to have the sort of workforce around you that is excited about coming in and working with you. And this is the best way to go about doing that. This is a business decision to provide you with a better product. And I don't think you have to be on the defensive about that. You can point to a study like this and say, people want this. And I'm so sick of having to be on the defensive as we cast this debate.
And one of the reasons I think we asked Ian to come here is because the work that your organization has done on exactly what this looks like, right? And that study and the value, the disproportionate value of independent contractors in the California economy is one thing, but also nationwide, the way that the knowledge economy really does depend in a large measure on ICs, and I think we don't have to be defensive about it at all. I can say from my own personal experience, and many of you have heard me tell this story. My wife has been a freelance or independent contractor for 20 years, and exactly the reasons that Laura was talking about. She wanted the flexibility. She didn't want to have to commute. She can work, 30 hours one week, and the next week we got a bunch of stuff going on with the kids, and so she can cut back and tell her clients, and manage that schedule. And she works as a consultant to the biotech world, to the International Cancer Genome Consortium, and charges rates that our industry doesn't even pay. And that's kind of story that says, well, yeah, that's very positive. Now, to come back to your question, one of the companies that she was working with lost their contract with the end client. So there's a new company, a new incumbent, it's a federal contract. And they came and said, well, you have to be an employee to work for us. And here's your non-compete, and here's your exclusive. And she said, no, thanks.
Right.
And that's a business decision that she made. It's a business decision that company made, and I think we're going to see some of that happen. And if it means we lose some qualified people out of our workforce, I think we have to bite that bullet.
Oh, I think that's inevitable. Workforce participation as a result of Dynamex will ultimately go down, and it will go down in marginalized communities. That's the really outrageous untold story here, and it's only going to get worse as courts interpret this law in really onerous ways.
Yeah.
So I'm kind of wondering if the ALC, I know the ALC has like this repository where these different cases are going into it, and we're kind of building this knowledge base. I'm wondering, are there statistics like this as part of that knowledge base that we as members can kind of pull on to make? There will be. Okay.
Yeah.
So there was another group that was mobilized a few years ago. I haven't really heard much about it lately, but contractinterpreters.com, and there was some good statistics on that website, and I'm wondering if some of those statistics can be absorbed by ALC through the survey.
I thought I went to it about a year ago, and I thought the URL was down. Is it still live?
Honestly, I'm not sure, but
Well, that's
But I'm
absolutely something
wondering,
we can work
the
on.
information has to be out there. Is that something
Francesco.
that ALC can absorb and kind of
Yeah.
take
Answer's
a stance
yes.
I mean,
on?
the answer is
Don't
yes,
argue us.
and
The answer's yes.
that's our job, absolutely,
Yeah.
to help
Yeah.
the effort to be organized, to get all of this content that we're talking about. Ian, thank you for offering that. We'll absolutely take that and any other supporting content and data you've got. We'll put it in our repository. Chris Carter spent so much time building it. You know, why not use it? So we're going to do that. But I did want to tag on to something you said, Ian, which I think is, what does the picture look like if language companies are forced to go away from the independent contractor model? And after putting a lot of thought into it and talking to a lot of different people in the industry, I think it's a pretty ugly picture when you think about it from these terms. And you know what? I'm going to disagree, Francesco. It's not the clients to suffer. It's the end clients. It's the individuals. So what I'm talking about is, what if my company was forced to go employee only? It would be really difficult for us, from an interpreting standpoint, to send people for appointments where we only get 1 or 2 requests a month in, I don't know, random languages like COSA or whatever. So that's part of it. But you think about who's going to suffer there. It's the people in the marginalized communities. You're talking about immigrants, refugees, medical appointments. You're talking about school parent-teacher conferences. IEPs. All of that stuff, they're the ones that are going to suffer. It's not the Spanish speakers. I mean, we've got a boatload of Spanish interpreters and translators. Yeah, it's going to be those smaller communities that need help maybe the most, and they're not going to get it. And I think that's something that we try to get through to the legislators during the lobbying efforts that we did in the state of Washington. I think almost to a person, none of them understood that until we talked about it.
And that's the thing, is that you guys, you're a very sympathetic group, and what I mean by that is that you have a story to tell, right? I mean, because the people in the legislature care about those people. Everybody cares about those people. They want to make sure, especially, you know, kids that have parents coming to parent-teacher conferences, have that relationship with their teachers, and that's a huge, you know, point. That the other thing that, and sorry, I'm kind of going off on a side tangent here, but the other question I got a lot of is, well, I love the idea of op-eds, but if we write an op-ed, then are we putting a target on our back? There's 2 ways to do that. I mean, you can go through your organization and have op-eds written without company names or without, you know, but with that kind of perspective and saying, hey, this is where we see the industry really suffering. And then the other thing is that if you put your head in the sand, it doesn't mean that the plaintiff's attorneys won't find you. And I don't mean to disparage the practice at all, because obviously that's what I did before I was lobbying, but that is who is going after individuals right now, and that's where the enforcement is coming from. And so we've had a lot of people say, you know, well, our attorneys told us not to write an op-ed. That's absolutely fine. But you can also still write a letter to your member, and you don't have to put your last name, or you don't have to put the company that you own or operate. You know, you can do things like that and say, hey, I'm one of your members, and I don't want to put this information in there just because of my own personal reasons, but this is why it's a concern to me. And there, you know, that kind of information gets out there. And the same thing, you know, with a meeting. If you meet with someone, again, it doesn't have to be a big target on your back because you're not in, you know, public forum. So those are kind of, but it is a really, I mean, you guys really do, you really do provide a very important service that I think you guys should really hone in on.
Thanks, Laura.
Mm-hmm.
I want to go back to the question a second ago, though, because when he asked this question, I'm thinking, well, why does his end user, who's hiring him to provide the service, care? Because they're not liable, or are they? Because I mean, that's a fair question. And one of the interesting wrinkles with Dynamex is, as I alluded to earlier, it creates a real problem if you winnow the concept of an independent contractor such that it's really hard to label someone as an independent contractor. Suddenly you get in situations where it walks like a duck, it quacks like a duck, it looks like a small business, someone who truly wants to be independent, and yet they flunk the B test because their business is this, providing the same thing as you do. That's a little crazy. But so you may have end users who are going to be scared of contracting with a smaller guy and with your firm. So I brought my son to Kaiser the other day for his 1-year checkup, right? And I noticed a poster that if I needed language translation services, that they would get someone on the phone to talk with me. Luckily, I didn't have that issue, but I'm sure that they have on contract someone to do that. And I don't know how they're classifying those people, but I think under Dynamex, they're probably flunking the B test because they're providing.
Absolutely certain that Kaiser has somebody in this room or somebody coming to this UnConference has that contract, and with subcontractors for certain, and they are using independent contractors, right? Because Kaiser, what we, and we know this well, but as Rick said, as Francesco alluded to, it's that patient, it's that person going to the school system, that they're the ones that are going to suffer. And Laura said, we have a really strong story to tell. It's also the jobs and the value to the economy. And I think, Ian, you had statistics, it's like 34% of the California economy depends on ICs.
Yeah.
Right?
We need that stat too. That's good.
Yeah.
It's all in the paper.
Okay,
Promise.
thank you.
Well, and the other thing is that it is protecting the small businesses, right? So that if not, we're going to have a monopoly of, one giant organization in each industry that's able to provide some sort of service, whether that be in, whatever the industry, healthcare, transportation, translations, services. So that's the other thing that is a really key piece here, that it's because of that model that you guys are able to become entrepreneurs and start your businesses.
Exactly. Kevin, I think we had a question back there. Jordan.
Yeah, hi guys, Jordan from Language Network, and I'm just trying to run an honest business in California. Call me crazy. So I got the privilege of hosting the ALC CEO Roundtable in November, and I think it was 5 of us came together, and 2 items that we kind of were takeaways. One, we all know this industry is highly fragmented, and there's all these different skirmishes going on the state level, on the federal level, on trying to find, is it an employee, is it a contractor? So I've kind of got a 2-part question, comment. On the offensive side, I would like to also request the ALC, since we're a gathering place, create some boilerplate talking points so that all of us can be talking heads when somebody asks us what's the stance on this in our industry. I say that to my legislator, I say that to my linguist. So that's my request, +1 to Francesco over here on us aggregating talking points. I'm trying to run a business, but I also want to know the talking points. So
Good news, Jordan. They exist and they're on the website.
Okay,
All
great.
right, so we've
Okay,
got
next thing then. Case law. How do we get more of this, and can we start a legal fund through the ALC, and we buy insurance, and then we pull that together to get more favorable case law? What does that look like? What would that look like?
We're a 501c3, right? We're C6. Can we even do that if we wanted to, or would we have to change our designation?
It's not lobbying to file an amicus brief.
Legal defense fund would be different.
Yeah.
We need to, ALC would have to talk to, a nonprofit.
Consultant attorney.
Well, I will sign up. I'll be the first one.
Yeah.
All right, Jordan, we will continue that conversation.
Okay, but my question for the group up there would be, what is the benefit of case law when dealing with this issue?
So I've been emphasizing this point all the time, but this is what we do at the NFIB Small Business Legal Center, is we're filing these friend of the court briefs, and in this explicit effort, and I know the chamber is also very aggressive on these things too. And the explicit goal is to either set good precedent or to avoid bad precedent. Now, granted, we got bad precedent with Dynamex, but the impact of that decision can either be limited or can be made worse, to be perfectly honest. A second ago I was talking about whether or not Kaiser is on the hook for your services, right? There's this real thing as a joint employer. You can be a joint employer with another business. So they have some potential liability if there's a misclassification issue, right? And if they flunk the B test. And so that's that. But so those sort of questions are going to be litigated. I'm not sure how the courts will resolve that necessarily. But when we see those sort of issues coming up on appeal, I know we're going to be very interested in limiting the damage here and filing an amicus brief. By the way, I think contributions to the NFIB Small Business Legal Center are tax deductible. But anyways, no, there's other organizations out there who are concerned about these things and are fighting on this as well. So.
Yeah. And the same thing, Cal Chamber does the same thing. I believe that we even filed an amicus brief with regards to Dynamex regarding the retroactivity piece that the court decided not to take up. So whether or not you guys are able to provide those services, there's definitely out there. And I mean, the business community as a whole is really focusing on that.
It's national and
yes, absolutely. Yep.
Well, and that's just it. So these are 2 excellent organizations. They litigate in a responsive way. In your industry, if you have very specific strategic goals that you want to achieve in litigation, that's going to require a different enterprise entirely.
So a related question, let me just throw this one in here really quickly, Mary, is related organizations, or I should say industries that are also knowledge-based, should we be talking to them? Like, who might you think reminds you of us and what we do? And have you seen coalitions like that work in the past?
Yes. Yeah, I mean, so there's a couple things. I mean, for you guys, you provide a service that is extremely important to especially California, who has such a diverse population. But there are other industries that might not be exactly what you do, but provide services like that. So we're looking at music schools. We have people that are part of the coalition that are youth referees. We have people that are part of the coalition that are youth coaches, things like that.
Part of I'm Independent?
Yep,
Okay.
part of the I'm Independent coalition. And again, that's, you guys are members, and again, that's free for anyone else to join, and to kind of come together and get that sympathetic voice out there to say, hey, this is what we're doing. And we have had actually the hospital specifically talk to us about you all. So, and things like that. So it is a great place to come together, but I can tell you the coalitions are hugely impactful. And that's really why labor's even giving anyone the time of day on this issue, right? I mean, they literally got handed Dynamex. They got the ABC test that they've wanted for decades handed to them on a silver platter. What would they going to do with it? They're going to codify it. But now they're getting pressure because of coalitions and businesses and independent contractors coming out and saying, this isn't fair. You can't do this to us. And that's why they're even giving the time of day to say, okay, yeah, we do need to rework this. And that's why the assembly members and the senators and the governor himself has just realized that this is an issue.
That's perfect. Thank you.
Yeah.
Luis?
Well, actually, yeah, I think you answered the question that I wanted to ask. Our industry is fairly small compared to any other industries impacted.
Yep.
And my question was, how can we join somebody that's in line with what we do?
Yeah, and that's exactly, I mean, it's a coalition, and that's exactly what you are doing, is joining and getting your voice heard, and you can make that as personal or not as personal as you want.
I would just mention, though, and I think this has kind of been said to some extent already, but I think there is concern in the coalition, among the coalition group members, about people sort of breaking off and trying to do their own thing. I think NFIB certainly wants to see a systemic approach to this.
Yes, absolutely.
I want to push back just a little bit on small. I mean, we see ourselves sometimes as a small industry, but again, I go back to what the Common Sense Advisory statistics have. On the one hand, 6,000 small businesses account for 80% of the revenue in the language industry, and that revenue estimates go from 15 to 40 billion per annum in the U.S., and roughly 250,000 people who make their living off of what we do. So that's not trivial. It's small out of an $18 trillion U.S. economy, but it's still not trivial. And I can guarantee that if you go to Sacramento or Lansing or wherever your state capital is, whatever office you walk into, there's going to be a language service company in that person's district. They may not be represented here at ALC, but they're not yet. Not yet, but you can walk into any office on Capitol Hill, and I don't care how remote or rural it is, there will be half a dozen or more language service companies at a minimum in that representative's office, and sometimes you get to the major cities, there are a lot more. And that's actually really powerful, because you can walk in, no matter who it is, and say, wait a minute, I know there are people in your district that are paying taxes, providing meaningful work for people in your district, and meaningful services for people in your district.
Absolutely. Jen, I think we had a question over there.
Thank you. Hi, I'm Nadia. So my question's around prong C of the test. So a lot of people were talking about how they have freelance translators, a lot of the same freelance translators. If they were to source their freelance translators from one common place, and almost saw them through a profile and were able to source them that way, would that overcome prong C?
What exactly do you mean by a common, like a repository, some sort of...
Like a platform, like a freelance sourcing platform, if they were all in one place.
Yeah, you could, insofar as they're putting themselves on that platform for the sake of getting business, I mean, that's an argument on C. I hesitate to say that it would be dispositive on C, but I think there's a way to frame that argument that it would help. I think there's going to, as I mentioned earlier, that part of C, at least so far the courts have said, is that they've got to have other clients. Part of C, I think, is demonstrating that they truly intend to hold themselves out of the world. So I think it much depends on how that platform looks, what that platform looks like, and what other things have they done to make themselves look like a business? Have they tried to incorporate? Do they have a taxpayer identification number?
Okay, so more on like tax logistics and whatnot, but like in the idea of having that open source platform where freelancers weren't really holding LSPs weren't really holding their freelancers so tight, but they were able to kind of source in more of an open space, and the freelancer was almost promoting themselves to these LSPs. Then the business model would flip a little bit.
Right. I mean, it sounds like I don't even know how I would go about finding, a translator if I wanted, right, a linguist if I wanted, but I mean, it sounds like you're talking about a Google to go and find those people specifically. And, I mean, theoretically, that could help.
But you're still going to potentially have an issue with B.
Right.
Yeah.
Right, but it would loosen up C a little bit, it sounds like.
Yep.
Okay.
But I mean, you got to get all three.
Yep.
Definitely helpful. Jen, you had another?
Okay. I just had a comment to the woman who's now gone. Okay, so I have a practical comment. My company has an authorized contractor program, and that authorized contractor program describes the relationship between the worker and our company, and that program matches the Borrello test as closely as possible. And I just wanted to encourage everybody to consider doing something like that. Ours is very strict. It's very similar to what some of my clients require of me to be a contractor. Apple Computer, we're an authorized reseller of Apple Computer. Same with Google. And it's the same type of thing. So we require business cards, business license, W-9 form, and all of these specific requirements, including a client list, a representative client list, website links, that sort of thing. So that's a really practical tip because you want to make sure that the relationship that you have with the worker reflects the model that you're trying to pursue to the greatest extent possible to mitigate the risk. So if that's an employee model, the relationship should be one of an employee. Excuse me. It's been a long day traveling from Brussels. And if it's a contractor model, that relationship really has to model that as much as possible. So that's comment number one. Number two, creative thinking. I'm really trying to figure out how to go forward here. And one idea that occurred to me this afternoon is if the state of California's focus is on protecting the worker, well, I would argue that contractors are working for themselves, especially ones that are described as sole proprietorships. Maybe we can come up with some creative ideas of how to focus on that. Right now in California, you're not required as a sole prop to have workers' comp. Maybe that needs to change, because if I'm going to make all my contractors employees, I have to absorb some of those costs. I'm going to pay them less. Well, maybe if they want to keep that flexibility, they can pay those costs themselves, and I can still, the money, the amount that they're getting paid doesn't change particularly, but maybe they should be compelled to have workers' comp and other benefits that are right now being forced onto the employers. They are employers. They're employers of themselves. They are businesses. It's B2B, business to business. So maybe we can creatively look at ways to change the legislation, if that is indeed what California is basing their argument on. If it's with respect to compensation and personal income tax, then there should be laws that require those contractors to prove their compliance with personal income tax withholding.
Thanks, Naomi. Any reaction from the panel to that concept?
It's kind of like the portable benefits idea, right? I mean, depending on what that looks like. And I know that there's a lot of entities that have independent contractors that have said we want to provide them benefits, but we can't because then that makes them look like employees. And then but if the state most likely wouldn't require them to get workers' compensation for themselves unless they had their own employees, and then they don't want to force them to have benefits that then cost more money out of their pocket. So that's the.
They don't want to create barriers. I like the way you're thinking.
Yeah,
because
definitely.
it is innovative.
Mhm.
It's very similar to the portable benefits thing. The question around that is where does that money come from? And the portable benefits proposals we've seen thus far are like they're not opt-in, they're compulsory. So I think a lot of workers would opt in if there was some small compulsory contribution on the part of the business. So yeah, businesses would probably adjust cash compensation down a little bit. But the fact is the the worker would see a benefit that was far greater because these benefits that they were able to purchase would be part of groups, right? So their dollar would go a lot further in that context. And so that's why it's such an appealing model moving to that, because then they get the purchasing power of purchasing in a group as part of this portable benefit administrator model.
And they get to retain the flexibility, which is what we need to compete internationally with a global mobile workforce.
Absolutely. Well, and you just said you came from Brussels, right?
Yes.
Well,
And-
Belgium has a third classification that looks a lot like this.
Yes, and so does England. It's new, so it's it's maybe a year old. Correct me if I'm wrong on that.
No, I'll just say one thing on that, and it is, I mean, I like the creativity, and I'm really interested in this portable, and I've heard some interesting proposals along those lines, not just with regard to this conversation, but, maternity leave and things like that as well, for people who are, changing jobs. But one cardinal rule that, of employment law in California, and I think generally in the United States, and that labor would push back very big on, is anything that would shift to the worker financial obligations for the cost of doing business, including the regulatory costs. So, for example, if it's an employee, you have to compensate them for miles driven on their car for your business purposes, and for expenses that they're taking out, for your business. And certainly, right now, employers are on the hook for workers' compensation, unemployment insurance. And by the way, workers' compensation in particular is really a big deal for a lot of the small businesses we represent. Probably not for you guys. I mean, even if you were to reclassify, probably not as big of a deal because they're not working in dangerous conditions or conditions where they're likely to be hurt. But labor would push back.
We do have interpreters who go into state mental health facilities and state juvenile justice facilities, and there are issues around that.
Yeah, that's a good point.
That's a challenge. Yeah.
So the labor perspective, I would say, is not undifferentiated, right? I think that you will have elements of labor that are implacably opposed to reworking the grand bargain. I don't think that is uniform. I think that that there are elements of labor that are susceptible to compromise in this way in particular. And what's been so frustrating is where you have seen portable benefits advanced at the state level, it's actually been the business community that's balked just because they don't want to be boxed in, because they haven't been forced into a situation like you're now going to start seeing with Dynamex.
Just talking about thinking creatively, I'm very intrigued by these policy solutions that frankly I haven't thought much about, but I'm a big believer in free market capitalism as a driving force for success in this country, and I think that at the end of the day, free market capitalism is going to give us a way around Dynamex, and I say that because I think there's the development in AI is incredible. And you've got some big companies right now working on that, and that's going to become a bigger factor in a lot of industries, and I imagine in this industry in particular, something you're just going to have to think about in the years to come. But you don't have to pay minimum wage or deal with lawsuits because you didn't give your robot its meal break. So
yeah, something to keep in mind certainly. Kevin, I think we had a question over there. Doug Strock.
Yeah, Doug Strock. Well, one thing that plagues our industry is really a lack of statistical information, and so we look for it where we can get it, and one of the places we get it is on like PROS, which is unsolicited feedback from the translators, and it says what's their likelihood of working with us again.
And just a quick pause, Doug. So PROS that he's referring to is a website that is essentially a bulletin board system for interpreters and translators.
Right, so you can go out there, you can look for a linguist and bring them on that way, look at their qualifications. They can also ask you to rate them as a linguist and how likely you are to work with them again. So it's kind of a two-way street. But we have maintained that as part of our ISO metric because it, for lack of anything else, it's a number that's out there and it reflects how well we treat the individual. And so it really isn't anything out there in the industry that you can look at and says, well, what's the industry score for this? It's really an individual company by company, but we pride ourselves on that metric. And I know that Camilo has a very similar metric than what we do in that same space. And so you can look at anybody's score out there. It's a very much a public information thing. The other thing I would say is that you're not going to be able to put a cost down to an individual who's not going to turn around and build that into their rate back to you. And if we cost ourselves out of the market in the U.S., we're going to find ourselves going all these places where they don't have those costs because the business is going to look for the lowest cost source of supply. And that's just Econ 101.
Well, and that's where California, for a long time now, you'd sit down with the legislator and they go, we're the 6th largest economy in the world, right? Regulatory arbitrage really doesn't apply to us. You want access to our market. And so that's why it is so frustrating, just because there is no other way but to engage with the California legislature and to stay engaged with the courts. Because these services, the services that your companies provide, are essential. And at the end of the day, costs are going to go up and it's going to hurt consumers.
Sure, but you don't have to work with California employees. I mean, you could contract with this guy in Houston or with someone in Brussels. And with technology this day and age, I don't think it's off the table to have send someone in who's we can Skype, we can there's all sorts of ways that things can be done. I don't know how practical that would be. In
California
practice.
Regulators always seem to find a way to have the long arm reach out across state boundaries.
Well, that would be an issue, a good issue for litigation, I suppose.
It certainly would. Kevin.
Okay. Hi. I didn't want to say much, but I think my friend Seamus said, Bill, you better talk. I got an EDD audit about, I guess, 10 years ago, and it was triggered by an unemployment insurance claim because most of our employees, by definition, are not employment law literate. They come from different countries, and they're still learning checking accounts, let alone what am I? At that time, I decided to convert everyone to an employee, and it was difficult, and it still remains so. Of course, it's added a lot to my overhead, but I think in the general look back versus what you're all toiling with today, it was a good choice. It's expensive. I have employees in San Francisco, which makes California employment law take steroids. So that's, we have to pay into a health insurance account and commuter benefits, cell phones, anything that they do, we're paying for it. So, but I think one of the big issues is the interpreting agencies not here with us, the ones that have absolutely no regard to who they're sending out, which sort of down levels the industry and makes anyone who says or proclaims their language competency it's really doing a great disservice to all the efforts that we are doing. So anyway, my 2 cents. Thank you.
Thank you, Bill. Jen?
I come from the great state of Utah, and we've also gone through an audit, and something that Utah did, which is unique, is they require all interpreters to get an occupational license. And the occupational license, in order to get the license, you have to present to the state certain documents. And that saved us in the audit. Because when they audited our records and they went down the list, they found that everyone we use has an occupational license. And they immediately set them aside and said, those are just like employees, so you're fine. So I wonder if any other states would consider doing that. Setting a licensing level where they're required to have insurance or a business license or whatever, is necessary. Something that the state controls.
So I can take that. the American Translators Association is looking at that and looking at the Utah model and has tried and helped with some of the folks in Colorado. And the idea of so I'm thinking of Giovanna at Cesco, that, yeah, exactly, that as a way of the signal of professionalizing the industry and coming to back what Bill said, and, you know, sending out whoever who self-declares that, yeah, I've got a, you know, level 3 proficiency in whatever, and just trust me to take when I'm fluent, right? But that's actually another national conversation, because the issue of credentialing, and there's some states that want to roll back credentialing and licensing requirements, which, you know, gives me a certain degree of pause. I want my gas fitter, when I buy a new dryer, I want that person to be licensed, okay? I don't want my house to blow up because they had somebody come in. There's a public safety element in that too. But yeah, so there's another national conversation that's kind of happening in parallel that I think is just at the beginning stages that we're tracking, because that, you know, you can see additional costs as a problem, as potentially being problematic, but also signaling professionalism and making it easier for us on the business side to say, well, wait a minute, we work with licensed professionals. You know, much as the plumbers and.
Right. I just want to mention, I'd like to share later I'll email you this a paper that I've been working on with the Federalist Society on occupational licensing, so I'll share that with you. But there are less burdensome ways to do the same thing.
Yeah.
You know, to have some sort of, even if you think that the mark of the state is somehow necessary to allow someone to enter their profession.
And we've looked at third party.
Yeah.
And, you know,
So I mean,
not
there's
necessarily,
third party ways. Yeah. There's certifications that are, you know, less onerous than you know, actually requiring someone to jump through the hoops of getting an occupational license.
Yeah. And I think we're open to the whole range of that, rather than saying we want to necessarily go to a state level license, because that has a lot of other complications to it.
But it's a good idea, like having the imprimatur as evidence, prima facie evidence of a particular status, you know. Yeah, I mean, I'm not familiar with the Utah experience. I would be hesitant specifically with the license, just because there are other ways of getting that imprimatur, I think, because the risk would be that you in some way restrict the supply of labor that you have potentially, because some states might introduce more, Utah is pretty good, but might introduce more onerous requirements when it comes to licensing.
Yeah.
But I see the problem you're trying to solve, and that's an innovative way of doing it.
So one thing I'll bring up, well, Bill, you mentioned the ATA, the American Translators Association. I think just about everybody here is familiar with that organization, and they are, as far as a group representing linguists, they're the biggest one in the country. They have approximately 10,000 members, as I understand it, and I had a chance to sit down with their leadership a few months ago, and I was really hoping that they would kind of get behind the I'm Independent movement. In fact, to a person, every single person I spoke to at their conference, at their event, said, yeah, I'm independent and that's where I want to be. But from a leadership perspective, they can't do it because they have members that are companies, they have members that are individuals, some are employees, some are independent contractors, so they're going to straddle the fence, unfortunately. So just wanted to make sure everybody's aware of that. We can't expect their support in any kind of legislative efforts, but at the same time, they said absolutely they're not going to oppose any efforts to, you know, support the model, independent contractor model. Jen, was there another question? Oh, Kevin?
Thank you. Jordan, I want to kind of respond back to a comment you had earlier as to what is being done, what can the ALC do? You mentioned something of a legal fund, but I want to share with you a little bit about what has been done. Thanks to Rick, we have sent out letters from the ALC to every one of our state assembly people, as well as our state senate, I believe. I know for a fact our state assembly. So that's been done. So every state assembly member knows what our industry does coming from us as an association. That's a huge step, number one. Highly encourage, on California. And I highly recommend, as a company, our company sent out letters as well to our respective local state assembly men and women. I highly encourage all of you California companies to do that. Send out that letter. We have a template, and everyone knows how to find me. If not, reach out to me. I will send you that template so that we are all on the same page as to what information we are sending them. We make a very clear distinction between who we are and the separation between us and the quote-unquote gig economy. Okay? So, to your point of sending the letters and getting the exposure and how impactful it is. That is how we get into bipartisanship, because there are a large number of elected officials on both sides that are very receptive to this, not just Republicans, not just Democrats.
Thanks, Seamus. Other questions? Oh, there we go. Steve Chu.
Hi, Steve. This is Steve. Question for Rick. To your comment about the ATA, the leadership not getting behind it, could the ALC organize the interpreters and the translators to that front? The like-minded interpreters and translators to get behind this effort?
That's a great question. It's something that we've thought about and discussed, but not at a great level. We could, conceivably, as individual company owners, contact our workers, educate them on this topic, and encourage them to join the I'm Independent movement. It's certainly, especially the ones I would think in California. That is conceivable. We, as a board, have not discussed this to the depth that we would need to make that a reality yet, but it's conceivable. So I appreciate you bringing that up because, yeah, it's been a topic of conversation.
Yes, basically ALC acting
as organizers, right?
Yeah, in the role of community organizer in a way.
Right.
So.
That is conceivable. So that's something I think, Mary, if you're already taking the note, that's perfect.
I just want to add a comment about that. Having been through audits and dealt with a lot of lawyers on these issues, we have to be very careful what we convey to the contractors. Especially in California, you don't want to be in a position where you can be accused of directing the contractors. So telling them that they need to be independent falls under that. It's better to reach out to other people who represent organizations who represent those people, indirectly, in other words.
Right. That's what I feel like the ALC is actually in a better position to advocate for that as opposed to individual companies doing it. So.
And I'll come back to Rick's comments on the American Translators Association, and we understand there's I think we have to be very clear, and I think Laura was talking about being at the table with labor. They're going to straddle the fence because there is an activist component of their membership. Interpreters that have been pushing the unions in various places, pushing for unionization, or pushing for even getting rid of the language service companies in some cases, particularly in the Pacific Northwest. And Sandy just gave me this look, and man, because I know she's got the scars. But at the same time, for the last 10 or 12 years, there have been strands in the annual ATA program on how to treat yourself as a business. So this is, people have proposed these strands, come not necessarily blessed by ATA leadership, but we all have the war stories of people who didn't know how to write an invoice. That call you get it, Saturday afternoon, hey, you owe me X amount of dollars, and who are you again? Did you submit an invoice? Did you sign it? All of those kind of war stories. So there is an educational component that I would say that the membership organizations representing the labor side are well aware of the need to professionalize, and that's part of their job, the need to professionalize the workforce. And there are ways of working collaboratively with those organizations to help improve that without having them necessarily sign on to I'm Independent, which as much as we'd like to see.
Right.
But yeah, I think there's a general understanding that, you come back to what the grand bargain, I think that Ian talked about. There's only so much money out there for compensation, right? And everybody's going to have to look at how that's divvied up. Part of the educational process for the independent contractors say, yeah, if you want to be an employee, you are not going to get as much money because that puts costs on the company on your behalf, right? And that's part of the independence, part of the argument about being independent, that when you receive the larger compensation, you're responsible for your own benefits and care and feeding, and then if you're asking the employer to take that on, then you're going to get less compensation. I think that's part of the national discussion too. That has to be, I think, more more forthright, and the unions don't necessarily want to slam the unions, but they aren't necessarily being fully upfront with their membership about it either.
No. And then the other thing that I forgot to mention earlier, as far as one of the potential effects of an employee-only model is, hey, if I've got to hire every single person as an employee that is doing language work for me, guess who's going to control the heck out of it? Right here. I'm going to tell you exactly which appointments you're going to. I'm going to say, you know, what you have to wear, what badge you're going to have, what dates you're not going on vacation. I'll be nicer than that. I mean, hopefully it won't come to that, but yeah, Chris knows. So anyway, Kevin.
And I think it's important for us to recognize that with the ALC, the vast majority of our members do operate under the independent contractor model. I know I do with my business. But I think it's also important for the ALC to recognize that not all of our members do. There's a time and place to utilize the employee model. There's a time and place to utilize the independent contractor model. And even though we are focusing on the independent contractor model right here because that affects the vast majority of us, we don't want to not acknowledge that the employee model works for some of our members.
That's a really good point. But I think you're right. The unsaid thing up here on stage is that my strong belief, both models are valid. And mixing models is bad. I think we all kind of understand and agree that that runs you afoul of the law. But there should not be a mandate that only the employee model is valid. So I mean, that's from a policy standpoint, that's been the ALC's stance the whole time. And you're absolutely right, Kevin. We have multiple members, ALC members, that use the employee model. Totally support that.
It comes back to what Luke started off very early on talking about, well, here's the courts imposing a model on an entire, not just on an industry, but on an entire state. And I think that's also contrary to, you know, the basic principles of free market capitalism. We don't want that either. We want to have that negotiation. We want to have the opportunity to have our voices heard, whatever model we're using, and have our voices heard in that discussion.
It's also contrary to democracy.
Awesome. Kevin, I guess we're going to go one here. Okay. Vic, how's it going?
Oh, thanks, Rick. So the issue that we run into frequently is with interpreters in languages of lesser diffusion. So let's say, for example, Marshallese or Chukese. We have interpreters that basically say, I'll work with you, but it'll be on my terms. I'm not giving you a business license. I don't care. You do what you want. So it makes things complicated because they get flown out for court hearings to various states. They're really in demand. Now, if I'm a state auditor and I look at this, I'll say that's your employee. Now, we agree with the interpreter here. We both agree that we're independent contractors. It's an independent contractor relationship. The state auditor will not look at it that way. So what are your thoughts on that?
Again, it goes to the risk. I mean, it depends on you working out that risk, how much you need that person to provide that service to you, and what the likelihood is of you getting audited or the likelihood is of you getting sued. Unfortunately, that's not something that we'd be able to tell you to do, but I completely understand and have heard from numerous people in so many different industries that say, it's not us. They want to be an employee. I could provide that for them, but it's their terms, and unfortunately, that's just risk analysis.
I'm sorry.
No.
But so this takes me back to my days in private practice when I was working with folks in highly regulated industries, and your lawyer's not going to give you the answer. Or at least your lawyer shouldn't give you the answer. Your lawyer should give you a spectrum of options, and you and your threshold as a business for the regulatory exposure that you're willing to accept given the business considerations of that particular case. That's what's in front of you. And so, because I've been talking to people and I've just been hearing a sense of frustration, like, why is there not an answer? Well, this is really an unsettled part of the law, and it's a really evolving, high salience public policy issue. And if you really want that contract and you have a really compelling business case, your lawyer's going to tell you that, it's just high risk, but maybe it works for you.
Right, so there's an element of risk tolerance, and I'm very risk adverse, which I think most lawyers are.
Well, that's why we're not in business.
Right, but most entrepreneurs are taking risks, right? And so sometimes I talk to people, I'm like, oh gosh, you're comfortable with that? Okay. But so I mean, there's that risk tolerance aspect to it, but at the end of the day, different businesses are going to make different choices, and you raise an interesting question. Like, so you got some that are operating this way and some that are operating that way. Is that problematic? Well, what I would tell someone is, well, the ultra-conservative, safest thing, least risk-adverse thing to do is treat them as employees, but there's burdens and costs associated with that, right? It may be that someone's not treating them as employees and they're treating them as independent contractors. I'm assuming we're outside of California for this hypothetical. Sure. And they might have some sort of efficiency and a cost advantage and competitive advantage for that reason. But they also might get hit with a lawsuit or an audit. And at the end of the day, let's assume that it's not settled and there's actually some sort of precedent on the matter. Well, then you've got something to go on. So, I mean, the reason I keep, hammering, go talk to an attorney in your jurisdiction where you're operating in is because they should be able to give you, based on the case law in that jurisdiction, sort of they're not necessarily going to give you definitive answers all the time, but they should be able to give you some guidance, and especially if there's been a case on point.
Yeah, very good point. Thank you. Kevin, we had somewhere in the middle. Doug.
Yeah, I was going to say, the law you tried to get passed in Seattle contained just that language that said it could be one model or the other, and that did not go.
Didn't go. Labor was against it.
Chris.
Kevin, another right there.
I think, I'm trying to remember, we went back from a few minutes ago. I think that we have two sides of our business. One, we do a lot of work with private sector, and we do also about half our businesses with government. And I find that they have completely different pressures on this topic with how we work with both of those from the client side. One thing we mentioned earlier was, the people that are really going to be hurt are the LEPs, the end users. I find that also, I think what a consequence will actually be for a lot of government agencies. Most of the contracts we see for solicitations, RFPs are, here are the top languages that we're going to potentially request, and if you're lucky, historical spend, but they also will always say things like, well, we don't know your industry, so you need to provide any language we might ask for at any time in the future, whatever. That's where we get into the issue with these long tail languages, and they come to us for things like Wolof and, Kinyarwanda. Actually, Kinyarwanda is not even that rare anymore. But the point is that, well, for some of us, the point is that it's these really weird requests that are the ones where you run into the strange things you have a hard time managing, and where you have someone work for you for 2 hours every 7 years. Mm-hmm. And they're the ones that might trigger this. But I also find that the government agencies are like, well, if you can't do it all and cut your cost by 20% because we're broke too, then we're going to go find someone else. But there is not going to be anyone else. I figure, the private industry, private sector, I feel like it's a smaller list of languages typically, depending on what they're doing. But I think it's the government agencies in this country that are ones that are also going to eventually get hurt, because they are required. I mean, they're literally required by law to provide these services to all these languages. And with this model, it's not sustainable. We're not going to be able to do it, and they're just going to run out of companies who are even going to provide the service.
And that's why I want you in a meeting with me, so that you can say that to their face and say this is an issue.
Right.
So true.
And believe me, we
Okay.
say that in Washington all the time.
So one of the things that we've been discussing is not mixing models. One item that you may or may not be aware of, we have people who do translation, written translation. We have people who do interpreting. So interpreters, this conversation, I believe, was, 90% of it could go toward interpreters. But written translation done by translators that are maybe they're project managers that are also translators. That's a sticky situation. Risky. Because you are mixing models. And I know that a lot of people have that model in their business. So if you were presented with that, and out of the state of, California, if you're looking at that from federal law, that's, again, another reason to go along with what Kevin's saying, what Chris is saying, that, sorry, ADD moment, that really, honestly, the law has to change. The model is setting us up for failure, and if we do not advocate to make these changes as an association, I'm sorry, I'm getting on the soap.
But there are plenty of other, industries in the exact same position. The truckers come to mind as another example. Yeah, the realtors, salon owners, as we've mentioned already. But photographers. I talked to someone the other day who said that the media industry. So talk to someone?
Journalists.
Yeah.
There's a lot of actually government employees that drive for on demand. There's a lot of them that are personal trainers. There's a lot of them that work for gyms that do spin classes. I mean, a lot of these people are having to get second jobs because the state doesn't pay them enough. So, I mean, I cannot even think of an industry that isn't touched by this in some way.
There you go. I think we had a question from Doug Strock.
Well, no, earlier you had talked about prior case law, and I know Francesco is very familiar with it, but Bill Graper thought he had found pretty much a magic bullet or a silver bullet against this, which was Dawes versus Connecticut. Maybe you can fill me in on that.
Yeah, so there was prior case law that we found. It was, I believe it was a visiting nurse. I mean, like I said, I haven't actually had to deal with this in Connecticut in like 6 years now, thankfully. And I think it had a lot to do with that case law that was found. It was visiting nurses, and they were in the same position where the visiting nurses were used as independent contractors back in, I think, the mid-90s. And that case actually prevailed against the state of Connecticut. So I'll definitely be sending that case law in to Chris.
So that would be helpful in Connecticut, right?
Yeah.
But
Info ALC.
But it's always so these issues are always so fact specific. That's the thing. So I mean that case law might have give you a good defense in Connecticut. Again, it's only persuasive authority in other jurisdictions. But what you really need, to be in the best position, it would be great if you could cite an opinion saying, well, we had a company that was providing linguistic services, and it was held to be an independent contractor. I mean, that's really the gold standard. But you don't always have that silver bullet. So work with the best case you can get.
Exactly. Our executive director, Mary, you had
Hi. Sure. Obviously, this has been as clear as mud, this whole discussion. But I'm wondering from the perspective of being of service to our members, and I've heard so many reactive stories in the room, how do we as an organization help our members be proactive, short of hiring an attorney like yourself? Is there a checklist? Is there something that we could advise them to do to help them set themselves up for success in this type of a situation?
You can go through a self-audit. I mean, you don't have to hire an attorney. It's the best practice to hire an attorney, but you don't have to. I mentioned our NFIB's guide to dealing with independent contractors. It lays out the federal tests. So, you can go through the 20 questions that IRS would ask and say, well, how many of these factors come out looking like an employee? How many come out looking like it's an independent contractor? You can go through the economic realities test that DOL uses, which is like 6 questions, 5 or 6. And then if you're in California, you got to go through those ABC tests, and you can probably figure those out, thinking about it. I mean, are there some gray areas where you would benefit from getting legal counsel? Yes, but self-audit's a good place to start.
Mm-hmm. Really good point. Also, there's content, there's documentation, and the knowledge base. You're talking about independent contractor forms, agreements. Certainly, I think a lot of it has to do with just, somebody mentioned earlier, documentation. Do you have 1099 forms for everybody? Do you have their business licenses for all the contractors you're working with? Things like that, or that all comes into play when you're talking about a self-audit, which I completely agree, I think is a great first step. Take a look at yourself, and then beyond that, if you need legal counsel, there are plenty of attorneys to be had, I'm sure. Just wanted to quickly mention before the next question, I think we're down to our last 10 minutes, so maybe like 2 questions. Stephanie, please.
Yeah, so when we talk about self-audits, so many of us have already been through audits particularly in California, the EDD. Our agency specifically went through an audit 2 years ago, and we passed, which was great. But now we look at this ABC test, we know we're going to fail B automatically. I mean, so I don't, what other self-auditing can we possibly do?
I mean, the fact that you pass the EDD is good for EDD, but it doesn't help you with regard to the wage and hour issues. Yeah. So,
it's that limbo. We're just kind of
so as a practical
assessing
matter.
risk.
So, I mean, if the practical matter, in order to be compliant with, you've either got to be sure that you're passing the Dynamex test, which you've concluded that you're not. That means that you either need to stop working with people in California, or you need to convert them into employees. I mean, if that's your conclusion that you failed the Dynamex test, I'm not giving you legal advice.
And again, that goes to what Ian was saying earlier, the risk analysis, right? I mean, attorneys are risk averse. I mean, I have medical insurance on my dog. I'm not risk averse. But, you know, you're going to have to weigh what that does for your business and the likelihood of you being faced with a lawsuit.
Excellent. Chris Carter?
Yeah, so actually, it's more of a comment. I think everyone here should be proactive and at least trying to learn more about the situation, which is why we're all here, of course. And luckily, the ALC is trying to put together stuff, information, organization, et cetera. But I would also recommend that as you all are educating yourselves, don't be afraid to educate your employees. Particularly when it comes to risk aversion mitigation, when you're dealing with all the things that you're doing internally with your company, with paperwork, with labeling, with how you do your production. Any of the things that you're doing inside your company, you shouldn't let it be undone by employees that are just filing things wrong or marking things wrong or any of that, because I've been teaching my staff about this for years, and they're teaching each other, and they're proactively kind of keeping track. I think that's also important to make sure that, you know, when you get audited, they don't care if you say, oh, my employee member did that wrong. Like, it just looks bad. So feel free. And they actually send me articles. I have employees that send me articles that they're reading up on this topic too. So I'm learning from all sides. So I would recommend just spread the word.
Excellent. Final word from the audience, Naomi?
Yeah, further to that, I'll be happy to share the details of our authorized contractor program with ALC in the forum. Because I think it would be a really helpful resource to people. And further to what you just said, I'll also share an example of our internal policy document, which helps educate all the employees of the do's and don'ts, especially what language to use, where semantics come into play, and this sort of thing can be really, really important in an audit, because you don't want anything undone by one employee.
Fantastic. That is much appreciated. And we talked about it, I think, in the first hour, how important that knowledge base is. And it is something where we need content. We need exactly what you're talking about, Naomi. We're going to take the content from Ian, Luke, Laura, whoever's got content to give. And it's going to be a repository that's going to be a real member value. And we hope that it's going to be valuable for you guys. Again, if anybody, God forbid, you're going through an audit, you need help, you know who to talk to. Talk to me, talk to Bill, talk to Mary, Susan, whoever, and we're going to do everything we can to support you. But the bottom line, it's a significant issue for our industry, and I personally appreciate the fact that you guys took a very good chunk of your day this whole afternoon to learn a little bit more. I'm even more grateful for our panelists. Thank you, Bill. Thank you, Ian, Laura, Luke. You guys have been fantastic. I was talking with Jen at the break, and we were just thrilled with how this has gone so far, so hopefully you guys got a lot out of it. We are, I believe, after this, on a little bit of a break before the opening reception.
Correct.
I think the panelists are all going to do shots in the bar. Yeah, totally.
What? Laura gets water.
Yeah.
You should water. That's fine. I joke. But we are very much looking forward to the opening reception. You guys certainly are invited if you have the time. We'd love to have you guys there. But other than that, Jen,
Get
any
back
closing
on that
remarks?
app. Everything Ian sends over, or anybody else, I'm also going to upload those to the app. The idea is keep up with this app. I'll put it under their pages for their bios. I'll also upload the documents that way, and any of their contact information that they want to share with us, I will get it on their pages on the app, and you guys will be able to reach out to them when you need to, if that's how they want everything to go.
Fantastic. Thank you, everybody.
Thank you, guys.